Good morning, everyone, and welcome to the 8th meeting for 2021 of the Justice Committee. We have apologies this morning from Liam MacArthur, who hopes to be able to join us later. We're joined today by the Cabinet Secretary for Justice, Hamza Yousaf MSP, his officials, and by Rachel Hamilton MSP, and I welcome them all to our meeting. We have a very congested agenda this morning. We have 2 legislative consent memorandums to consider, 1 bill to consider at stage 2, 2 affirmative instruments, 1 negative instruments, and 2 further matters of business thereafter. My first question to the committee is, are we content to take the last item of business in private, the last item being a note from the clerks about malicious prosecutions and the Crown Office? Are members content to take that matter in private? Members are content. Thank you. Our next agenda item is the committee's consideration of 2 legislative consent memorandums in relation to 2 United Kingdom government bills, namely the Financial Services Bill and the Counter-Terrorism and Sentencing Bill. And I refer members to the relevant paper in our pack, which is a note on these bills by the clerks. And do members have any comments on either of these legislative consent memorandums? I call John Finney, please.
Thank you, Convener. I would like to ask the Cabinet Secretary to expand on 2 matters, please. A simple explanation. Is the UK Government seeking to fetter ministerial decision-making regarding sentencing in Scotland? And clarification about Scottish Government's position on the use of polygraphs, please.
Thank you, Mr. Finney. Those are questions for the Cabinet Secretary. I'm not sure if we have the Cabinet Secretary with us at the moment or not, but if we do, I wonder if he could address those questions from Mr. Finney, Cabinet Secretary. It might be, Mr. Finney, that we have to come back to that issue. The Cabinet Secretary is joining us for later agenda items, including stage 2, but I'm not sure if we have access to him at the moment. Perhaps we should postpone consideration of this item until after we have the Cabinet Secretary with us. Are members content to do that? I think members are content to do that. The next item of business that we have is stage 2 of the Domestic Abuse Protection Scotland Bill, and we certainly need the Cabinet Secretary to be with us for that.
Oh, is it really?
We certainly need the Cabinet Secretary to be with us for that agenda item. So can we just pause? There's no need to break broadcasting, but can we just pause for a moment? So we can...
Nice.
There's a very severe danger that this is going to go viral. Okay, I'm being advised, colleagues, that the Cabinet Secretary is scheduled to join us from 10 o'clock this morning. So we will try and transact as much of the business that we have in front of us today that does not need the Cabinet Secretary's attendance, and then pause until 10 o'clock. And at 10 o'clock, Mr. Finney can put his questions to the Cabinet Secretary about the LCMs, and we can then proceed with the agenda. So I apologise for mixing up the agenda in this way, but the first item of business on our agenda that does not require the input of the Cabinet Secretary is agenda item 8, which is consideration of the negative instrument, namely the Restorative Justice Prescribed Persons Scotland 2021 order. I refer members to the relevant paper in the pack, which is paper 5, namely a note by the clerk. Do members have any comments on this negative instrument? members are indicating that they don't have any comments on this instrument. Are members content not to make any comments on this instrument to Parliament? Members are content. That concludes consideration of that instrument. The next, and I think final item of business today that does not require the input of the Cabinet Secretary is consideration of a report back from the meeting of the Justice Subcommittee on Policing that took place on the 15th of February. Again, I refer members to the relevant paper in our pack, which is paper 6, namely a note by the clerk. And can I invite John Finney to indicate whether he wishes to supplement his written report if there is anything further he wants to add? Up to 10 minutes, Mr. Finney.
I can speak very slowly if you like, Convener. Convener, I've nothing to add to the report, but as ever, I'm very happy to take any questions that members may have regarding the content.
Thank you, Mr. Finney. Do members have any questions for Mr. Finney about the content of this report? Members have no questions. So that concludes our consideration of that item. I await advice as to whether the Cabinet Secretary can join us now or whether we have to pause until 10 o'clock.
I am here, Convener, if that's helpful.
Thank you, Cabinet Secretary. Are you content for us to proceed, even though we're a bit advanced at the time we asked you to join us?
Yes, forgive me. My apologies. I didn't realise you would be done so soon.
No, nothing to apologise for, Cabinet Secretary. It's not on you at all. So we were considering, Cabinet Secretary, the two legislative consent memorandums that we have in front of us today. And I know that you were not expecting to give evidence on either of those, but Mr. Finney has raised two questions about them, and I was wondering if he could put them to you while everyone is here.
Oh, yep, sure.
Thank you very much. So, Mr. Finney, could you ask your questions again relating to these LCMs so the Cabinet Secretary can hear them? Thank you.
Thank you, Convener, and good morning, Cabinet Secretary. Cabinet Secretary, it was regarding two issues, whether, and an opportunity perhaps to state on the record, it's with regard to, I think, clause 33 about polygraphs. Can you state the Scottish Government's position on this? As you know, it's a widely discredited system, Amnesty, and I should declare membership of that organisation, and others have expressed grave reservations about it. So can you state the Scottish Government's position on that? And also with regard to the generality of that LCM, is this an attempt by the UK Government to interfere with existing powers of Scottish ministers regarding sentencing? Thank you.
So if I can make a couple of points, can I thank John Finney both for his questions, but also his long-standing interest in issues in relation to counter-terror, but also the human rights implications, and I'll come on to that in a second. You'll remember, of course, the original proposal from the UK Government was to extend the use of polygraph testing into the Scottish justice system. I took a very robust approach in opposition to that introduction, but also, again, as John Finney rightly alludes to, that wasn't just the government's position. A number of human rights organisations and indeed a number of people in the legal profession had a fair degree of concern at the thought of the introduction of polygraph testing into Scotland in any way, shape or form. It would be unique. It is, in fairness, not unique in England. Polygraph testing is used in some very limited way within the justice system in England and Wales. So I was pleased, of course, that our argument was persuasive enough to the Lord Chancellor, Robert Buckland QC, with whom, in fairness, I have a very good relationship with, and he agreed to remove those provisions within the legislation. In terms of the broader question, the second question that John Finney asks, yes, it does. The bill does, impinge on the Scottish Government's competence and powers in relation to sentencing, and that is why obviously we have them in front of us. I have agreed to the LCM in a limited way that it does potentially affect Scottish Government's sentencing powers, but in that limited way we are content to give consent. I won't, Convener, go into the greater detail on my reservations about the reserved areas of the bill, but it's fair to say that I associate myself with the remarks of Amnesty International and a few other organisations around some of the provisions in the reserved areas of the bill.
Thank you very much, Cabinet Secretary. Mr. Finney, do you have anything further you wish to explore on this?
Thank you, Convener. Just to thank the Cabinet Secretary, because although there's a lot of information in our papers, that's not necessarily so accessible to anyone who may be listening in. So it's very helpful to have Scottish Government's position confirmed by the Cabinet Secretary, and I thank him for that. That's be concluded. Thank you.
Thank you very much, Mr. Finney. That's very helpful, and I agree it's important to get these matters on the record wherever possible. Do members have any further comments on either of the legislative consent memorandums in front of us this morning? If members have no further comments to make, are we agreed that the Scottish Parliament should give its consent to the relevant provisions in these bills? We are agreed, and are members content to delegate to me the publication of a short factual report on the outcome of the committee's deliberations on these legislative consent memorandums today? Members are agreed. Thank you very much. So we now move to agenda item 3, which is stage 2, consideration of the Domestic Abuse Protection Scotland bill. So for this purpose, members should have with them a copy of the marshalled list and the groupings for debate. And I also refer members to paper 2 in our pack, which is a letter in relation to the bill from Police Scotland, who you will recall gave evidence to us in our stage 1 inquiry about the bill. Before we start, can I just remind everyone that as this is a fully virtual meeting of the Justice Committee, we will use the chat function on BlueJeans as a means of voting electronically today. When I call a vote, I will ask members to type Y in the chat function to record any votes for yes. And then I'll do the same for no, typing N, and abstain, typing A. The clerks will then collate the results, and I will read them out and confirm how each member has voted. If a mistake is made and your vote is incorrectly recorded, or if there are any issues with voting, then please immediately let me know by typing R into the chat box before I move on to another vote, as once we've moved to another vote, we cannot then go back. If we lose connection at any point, I'll suspend the meeting to try and get the member back. If we cannot do so after a reasonable period of time, I will have to deem that member as not present and then consider with the deputy convener if we can fairly proceed with the meeting or if we will need to postpone until next week. If that is clear and there are no questions, then we will make a start. So, the first group concerns domestic abuse protection orders and notices and the requirement for persons A and B to live together. I call Amendment 1 in the name of the Cabinet Secretary, group with Amendments 2, 3 and 4. Cabinet Secretary to move Amendment 1 and speak to all amendments in the group. Cabinet Secretary.
Thank you, Convener. I will speak to the amendments 1 to 4 lodged in my name, and I move them as well. And again, I welcome this stage 2 session. During the scrutiny of the bill, there was an important consideration as to the practical and operational challenges of the bill, and you referenced the Police Scotland letter on some of those practical and operational challenges, but in particular there was a concern around, or having a regard to, the potential volume of cases where domestic abuse protection notices and orders may be used. And we know the primary purpose of the protective orders and indeed the protective notices is to allow for short-term emergency protection to a person at risk of domestic abuse. This provides them with breathing space, time free from the risk of interference by their abuser to take their own longer-term steps to address their safety and possibly their housing situation too. As members will be aware, the need for this protection is most acute when person A, the alleged abuser, and person B, the person at risk, live together. This is because in that situation, person B is more likely to lack the freedom to take the action necessary and to protect themselves. It's always been anticipated that the DAPNs and DAPOs would be used predominantly where person A and person B live together. Recognising this and following discussions with Police Scotland and also with Scottish Women's Aid, I ask members to support Amendments 1 to 4 in this group. These amendments add a requirement that person A and person B must live together some or all of the time as one of the conditions to be met in order for a DAPN or DAPO to be made. Amendment 3 is the main amendment and amends Section 1.1 of the bill with the effects that DAPNs and DAPOs can only be made if, in addition to the existing conditions as to age and relationship, person A and person B live together some or all of the time. This approach ensures that a DAPN or DAPO can be used in a case where a person lives with their partner some of the time, but for example may have another home where they sometimes live. Amendments 1 and 2 make minor adjustments needed to pave the way for the new subparagraph inserted by Amendment 3. Amendment 4 is a minor technical change to reduce the risk of confusion arising from a redundant reference elsewhere in Section 1. So I move Amendment 1 in my name.
Thank you very much, Cabinet Secretary. Do any members wish to speak in the debate on this group? No members indicated that they do wish yet. No members indicating that they wish to speak in the debate on this group, Cabinet Secretary. So would you like to wind up and press Amendment 1?
Nothing to wind up, and happy to press Amendment and move Amendment 1 in my name.
Thank you very much. The question is that Amendment 1 be agreed. Are we all agreed? We are agreed. I call Amendments 2, 3 and 4 all in the name of the Cabinet Secretary and all previously. And I invite the Cabinet Secretary to move Amendments 2, 3 and 4 on block.
Moved on block, Convener.
Thank you. Does any member object to a single question being put on Amendments 2, 3 and 4? No member objects. The question is that Amendments 2, 3 and 4 are agreed. Are we all agreed? We are agreed. The question is that Section 1 be agreed to. Are we all agreed? We are agreed. The question is that Section 2 be agreed to. Are we all agreed? We are agreed. Thank you. We move to the next group, which concerns what constitutes abusive behaviour, additional examples. And I call Amendment 28 in the name of Rachel Hamilton, grouped with Amendments 44 and 45. Rachel Hamilton to move Amendment 28 and speak to all amendments in the group. I'm not sure we have Rachel Hamilton with us. So what I will do is just to move. I don't intend to speak to any of these amendments. Oh, you are here. Great. Rachel, in that case, would you like to move?
Here. Yeah. Yes, Convener, I move the amendment in my name. Would you like me to speak to the amendment?
Yes.
Convener, can you hear me?
Yes.
I want to take this opportunity to explain my intentions behind Amendment 28. It centres on the financial abuse that can arise when a perpetrator can still gain access to assets or money that belong to a survivor. An example of such would be perpetrator A can access a joint bank account in the name of survivor B and coercively control them through financial means, even once the relationship has ended. It's been widely recognised that financial abuse, a form of domestic abuse, can continue to offer post-separation. And 1 in 5 women and 1 in 7 men in the UK have experienced financial abuse from a current or former partner, according to the Cooperative Bank and Refuge, and 1/3 of victims didn't tell anyone at the time. It was raised during the passage of the 2018 Domestic Abuse Scotland Bill as to whether the definition of financial abuse was sufficiently encompassed into the definition of abuse. I engaged comprehensively with stakeholders on this groundwork for the amendment through engagement with the local charity Borders Women's Aid. I incorporated action points they raised. The amendment uses the same definition as the UK bill currently going through Westminster in the UK domestic economic abuse is covered. Currently, Amendment 149, lodged by Baroness Lister in House of Lords, follows a similar line of motivation to my amendment. When engaging with the Law Society of Scotland, they said, and I quote, "At the Society, we have not become involved in the detail of the conduct or behaviour which may form part of the reasonable grounds for a DAPN, as we discovered that this was much for the government in their policy objectives for the bill. We suspect that this is rather broadly framed, but it could be useful to examine what is considered to be an amount to reasonable grounds, which remains a concern as to exactly how much evidence is required before a decision by the police is made for a DAPN to be made. The problem with money-related matters is that it would need to be in some form of continuing conduct, not on one occasion, and also it may depend on other financial arrangements between both parties. For clarification, I intend for this to cover continuing forms of conduct, not a one-off occasion. And the purpose of this amendment is a probing one, to seek clarification from the Justice Secretary as to whether victims and survivors of domestic abuse are fully protected against coercive control in a financial context. In addition, it is to ensure that when a DAPO or DAPN is issued, that financial abuse is taken into account under the draft powers in the bill. Thank you.
Thank you, Rachel Hamilton. Do any members wish to speak in the debate on this group? No member has indicated yet that they wish to do so, so I will invite the Cabinet Secretary to respond. Cabinet Secretary.
And thanks also to Rachel Hamilton for putting forward what she describes as probing amendments, and I think it's helpful to have the discussion so that we can provide absolute clarity. On the records, can I also thank Borders Women's Aid for engaging with Rachel Hamilton, but also raising these issues and doing the good work that they do in the local borders area. I think these amendments are very well intentioned, and Rachel Hamilton has raised them previously, I think, in the Chamber with me before. I think it is important that the definition of abuse used in the bill is wide enough to ensure that financial abuse of the kind covered by Amendments 28 and the sharing of intimate images covered by Amendments 44 and 45 are included within it. And I hope to give Rachel Hamilton an assurance that they absolutely are within the definitions of the bill that we are using. These amendments, they're unnecessary, but my concern is also that they could have some unintended adverse consequences, and I will come to that in a second. Members are aware that Section 3 of the bill, as currently framed, provides a description of what constitutes abusive behaviour by person A, and the test is modelled very much on the definition of abusive behaviour used in the domestic abuse offence contained in the 2018 Act. That definition was developed following really extensive engagement with stakeholders, including Scottish Women's Aid, Assist, Police Scotland, the Crown, and is intended to provide a comprehensive statutory definition of what constitutes domestic abuse. Section 3 makes it clear that behaviour which is abusive for person B includes in particular two kinds of behaviour. The first kind of behaviour is behaviour directed at person B that is, and I quote, violent, threatening or intimidating. The second, which is particularly relevant to Rachel Hamilton's amendments, relates to behaviour which is abusive of person B by reference to the effect the behaviour is intended to have, or that would be considered by a reasonable person likely have in person B. This approach is intended to bring within the scope of DAPNs and DAPOs all behaviour that is controlling, coercive and emotionally or psychologically abusive. The list of relevant effects specifically includes controlling, regulating or monitoring persons B day-to-day activities, and depriving person B of or restricting person B's freedom of action. As such, the conduct of the kind set out in the amendment, particularly Amendment 28, is captured by the definition of abusive behaviour in the bill. If I turn to Amendments 44 and 45, which I think are equally important to probe, where a partner or ex-partner threatens to or does disclose an intimate image of person B, again, this would already be captured by the definition of abusive behaviour under the bill. Specifically, Sections 3.2a of the bill covers behaviour directed at person B that is violent, threatening or intimidating, and Section 3.3e of the bill provides that abusive behaviour includes behaviour which has at its purpose or likely to have in its effects frightening, humiliating, degrading or punishing of person B. The definition in Section 3.3e would capture sharing or threatening to share intimate images of person B without their consent, while the definition in Section 3.2a may also capture such behaviour depending on the exact circumstances. I think it's also important to remember that the description in Section 3 is non-exhaustive, and it therefore remains perfectly possible for the court to determine that behaviour is abusive, even if it doesn't fall within the scope of Section 3, providing that the court is satisfied that a reasonable person would consider the behaviour is likely to cause person B to suffer physical or psychological harm. So, Convener, while the definitions of abusive in the bill already covers the area included within the amendments, I do have some concerns about the practical effects of these amendments if they were agreed. They would result in the definition of abusive behaviour in this bill being inconsistent with the widely supported definition of abusive behaviour used for the domestic abuse offence, the 2018 Act. its inclusion could have unintended consequences by calling into question the operation of the domestic abuse offence, which would not be desirable at all. Therefore, specific further provision in these areas, while well-intentioned, is not needed. I hope that does answer Rachel Hamilton's questions. I note Scottish Women's Aid have also provided a briefing where they raise quite similar concerns too. It's for these reasons, and hopefully having given reassurance, I would ask Rachel Hamilton not to press these amendments, but if she does, then for members to vote against Amendment 28 as well as the other amendments in this group.
Thank you, Cabinet Secretary. Can I ask Rachel Hamilton to wind up and press or withdraw Amendment 28, please?
Thank you, Convener, and I thank the Cabinet Secretary for his clarification. And I just wanted to comment finally on the fact that at the moment, through mainstream media, women are being held hostage to image, and the possession of these images can be used to coercively control a victim if they're released or distributed and used as a threat. And ultimately, they can be used as an instrument of control. And I appreciate the Cabinet Secretary's acknowledgement of these serious matters. But I am satisfied that both financial abuse and the threat of revenge porn are covered by the 2018 Act, and no specific provision is required. And I won't be pressing my amendment. Thank you, Convener.
Okay, thank you very much. So Rachel Hamilton wishes to withdraw Amendment 28. Are members content that Amendment 28 be withdrawn? Members are content. I call Amendment 44 in the name of Rachel Hamilton, already debated with Amendment 28. Rachel Hamilton to move or not move?
Not moved.
Thank you. I call Amendment 45 in the name of Rachel Hamilton, already debated with Amendment 28. Rachel Hamilton to move or not move?
Not moved.
Thank you. That's not moved. So the question is that Section 3 be agreed to. Are we all agreed? We are agreed, and we move to the next group, which concerns domestic abuse protection orders and notices, the requirement for immediate or imminent risk of abusive behaviour. And I call Amendment 5 in the name of the Cabinet Secretary, grouped with Amendments 11, 12, 14 and 17. Cabinet Secretary to move Amendment 5 and speak to all amendments in the group. Cabinet Secretary.
I will speak to Amendment 5, 11, 12, 14 and 17 lodged in my name. Committee did hear at stage 1 from Police Scotland, who expressed some concern that they didn't consider it was sufficiently clear on the face of the bill that DAPNs are intended to be emergency measures intended to address those cases where there's an immediate risk of harm. Detective Chief Superintendent Sam McCluskey said, and I quote, "There is no component of risk in Section 4. That is really important. People use the term emergency order. The police officer's decision on such an order will be risk-based." But on the back of that evidence session, we engaged extensively with Police Scotland, as we had done prior to the bill being introduced. After their evidence, where they expressed similar concerns regarding the test to be used by the court for making a DAPO, and when it would be appropriate for the police to make an application for a DAPO, we decided to bring forward this amendment. I would say in the bill as it currently stands, the police can only make a DAPN if they consider there are reasonable grounds for believing that it is necessary to protect person B from abuse by person A during the period before a sheriff can make a DAPO or indeed an interim DAPO. Similarly, when a court is considering whether to make a DAPO, they can only do so if they consider that it is necessary to protect person B from the risk of abuse by virtue of this necessity test. And in view of the fact that a DAPO can only run for 2 months, extendable obviously up to 3 months on application, I consider it's implicit that the sheriff would have in mind whether person B was at an immediate or imminent risk of harm in deciding whether it's necessary to make a DAPO. But in light of the concerns expressed, I consider there is some merit in making this clearer on the face of the bill. So Amendment 5 adjusts the test for making a DAPN so that police are required to have reasonable grounds for believing that the DAPN is necessary to protect person B from the risk of immediate abusive behaviour by person A. Immediately is defined as meaning in the period before a sheriff could make a DAPO or an interim DAPO. Amendments 11 and 12 make consequential changes to Section 6 in respect of the information to be contained in the face of a DAPN. Amendment 14 adds a third issue to the matters as to which the sheriff must be satisfied in order to make a DAPO. The effect is the sheriff can only make a DAPO where there is an immediate or imminent risk that person A will engage in further abusive behaviour towards person B. Amendment 17 provides that in deciding whether it is necessary to make a DAPO to protect person B from abusive behaviour by person A, the sheriff can have regard to any risk of abusive behaviour that may occur at a later point in time, as well as the immediate or imminent risk of abusive behaviour which requires to be present before a DAPO is made. Convener members will be aware that similar powers in other jurisdictions are often referred to as emergency barring orders, and these amendments are intended to more clearly focus Part 1 of the bill on those cases where the risk to person B from person A is likely to manifest itself immediately or imminently if protection is not put in place, while still allowing protection to be put in place as necessary for up to 2 months. I move Amendment 5 in my name.
Thank you very much. Cabinet Secretary Rhoda Grant has indicated that she wishes to speak in the debate on this group. So can I call Rhoda Grant, please?
Yes, I'm just really looking for some clarification. I was quite concerned when the immediately section was added to the bill, because it seems to me that if someone is in danger, they need to be protected. And I think putting immediately into the bill then puts another barrier in the place of the police who might be looking at this and having to assess whether this is an immediate threat or whether that person is in danger. I believe if that person is in danger, they should have protection. So I'd like to have some clarification on that issue.
Thank you, Rhoda. No other member has indicated that they wish to speak in the debate on this group. So can I invite the Cabinet Secretary to respond to what he's heard and to wind up, please?
I can give some reassurance to Rhoda Grant, and equally if she's not necessarily reassured by what I have to say, we did discuss this issue quite extensively with Scottish Women's Aid, and again in the briefing that you will have received, you'll note that they are in support of these amendments because, for the reasons that I've already outlined, all they really do is clarify the use of and the test for a DAPN as an emergency order. That is the purpose of it as an emergency order. You'll remember that in my stage 1 evidence I had discussed potentially bringing forward an amendment around creating a higher threshold of test, i.e. the threshold of significant harm. But it became very clear from our engagement with Scottish Women's Aid that that would not be supported. So what we did decide to do was clarify that the emergency powers that a DAPN, the emergency powers of a DAPN are only used as an emergency order, and therefore there would have to be the risk of an immediate or imminent harm. Of course, if there's harm that could be, there's a risk of harm in the future, then of course that can be taken into consideration as well, particularly when there's a DAPO consideration by a sheriff, as I've already said in my remarks. So this shouldn't do anything to alter the test at all, but should just make it very clear that immediate or imminent harm is something that has to be taken into consideration by a police officer.
Thank you. So the question is that Amendment 5 be agreed to. Are we all agreed? We are agreed. And we move to the next group, which concerns a child living with person B. And I call Amendment 46 in the name of Rhoda Grant, grouped with Amendment 47. Rhoda Grant to move Amendment 46 and speak to both amendments in the group. Rhoda.
Thank you, Convener. I move Amendment 46 and speak to Amendment 47. Domestic abuse damages a child's life. Their resilience and self-esteem are damaged, as are their life chances. And they don't need to be a victim themselves. They don't need to experience it themselves. Tension and fear that surrounds them creates that fear and insecurity within them. Although children are offered protection under the bill, it's attached to their parent. I truly believe children must have access to such protection in their own right. The NSPCC in Scotland has reported a 30% increase since last April in referrals made to agencies regarding children in abusive households. And that comes at a time when children are more isolated. They're trapped in those abusive households without the respite and support of getting out to school. The incidence of domestic abuse has increased, and therefore its impact on children has increased. If children are contacting agencies for support when they witness such abuse at home, surely they themselves should be entitled to protection and have that abusive parent removed. This happens in other countries such as Australia and New Zealand. Such measures are very seldom used, but it can offer another protection for children. My amendments seek to do this. Amendment 46 with regard to domestic abuse protection notices, and Amendment 47 with regard to domestic abuse protection orders. They allow a child to seek a notice in order for the protection of the parent from domestic abuse. That protection extends to the child with the removal of the abusive parent from the home.
Thank you, Rhoda. No other member has indicated at the moment that they wish to speak in the debate on this group, so can I call the Cabinet Secretary, please?
Yeah, thank you very much, Convener. I will speak to Amendments 46 and 47 by Rhoda Grant, and I listened to her remarks. I'm slightly unsure about what the practical implication or effect is meant to be of these amendments, but of course Rhoda Grant hopefully can clarify. In summing up, but before I go into some of the detail, I think it's important that we've heard from Rhoda Grant quite rightly the real and negative impact that domestic abuse can have on children. I know Rhoda Grant has a long history in efforts in this area, and these amendments I know do seek to respond to what is a very, very important issue. But as I say, I'm not entirely sure what is being sought by these amendments. So for me, I know Rhoda Grant had said at stage one that she would lodge amendments to provide for a DAPN and subsequent DAPO to directly protect a child. What I'm not sure about is the practical effect of amendments 46 and 47, because what they look to do, what they do actually is allow a child to apply for a DAPN or DAPO on behalf of their abused parent or carer. And we should bear in mind, of course, the bill doesn't allow that for the abused parent or carer themselves. It is the police who apply for a issue a DAPN and then apply for a DAPO to the court. If the intention of the amendment is to provide for a supplementary DAPN or DAPO to explicitly protect a child, such an approach would not be consistent with the nature of the short-term protective measure contained within the bill. I mean, as members know, these are concerned with the protecting a person at risk of domestic abuse from further abusive behaviour by their partner or ex-partner in order to provide breathing space for the person at risk to consider their longer-term options. Any requirement or prohibition in a DAPN or DAPO must be necessary for the purpose of protecting the person at risk of abusive behaviour by the partner or ex-partner. The operation, therefore, of a DAPN or DAPO may have the indirect effect of protecting a child that resides with person B from the effects of domestic abuse through, for example, the removal of person A from the shared home, and indeed the imposition of conditions prohibiting person A from contacting or approaching or attempting to approach or contact any children usually residing with person B. However, where there is a need for direct protection of a child, then there is a separate child protection regime, and in my view, it is that regime which should be used for the seeking of protective measures of a child where necessary. However, if instead Rhoda Grant's intention is that a child should be capable of applying for a DAPN or DAPO on behalf of a parent, and that seems to be the effects of her amendments, then that is also not something I can support. I don't consider it would be appropriate for the bill to contain provisions which would enable a child, and indeed put the onus on a child, to seek to engage in these processes on behalf of an abused parent. If a child is concerned about their parent carer being the victim of domestic abuse, then the appropriate mechanism would be for the child to report such concerns to the police, either directly or through a trusted adult, who may then respond appropriately to the individual facts and circumstances of the case, which may, of course, in the end result in the imposition of a DAPN and the application of a DAPO. Such an approach would also create an inconsistency with the current approach, whereby the person at risk, as I say, could not apply for a DAPN or DAPO, but yet a child could. I think for all these reasons, and perhaps if we could get a little bit more clarity on the intention behind this, I would ask the member to withdraw amendments 46 and not to move Amendment 47.
Thank you, Cabinet Secretary. Could I ask Rhoda Grant to wind up and to press or withdraw Amendment 46? Rhoda.
Yeah. The victim of domestic abuse quite often hides the crime themselves. That is one of the difficult things about domestic abuse. It's only when the victim decides to ask for help, and of course the conduct that goes before that is often lost just simply because the victim themselves has covered up that crime. However, a child is aware of that crime being committed and is damaged by being witness in some way to that crime being committed. And as I say, that doesn't mean that the child itself is damaged. What it means is that the child is living in a household where domestic abuse occurs. Now, this bill doesn't offer a child any protection in its own right. And the Cabinet Secretary rightly says that if the child itself is abused, then there is child protection legislation in place. But that requires physical abuse to the child themselves. But in this case, the child is damaged not by the direct abuse of themselves, but by the abuse of their parent. So therefore, I believe that there is a gap here where the child is not being protected from the damage that is caused to it by the abuse of their parent. My amendments seek to allow a child through a third party, possibly NSPCC for instance, to ensure that the police will investigate and put a notice in place when they raise the alarm to say that domestic abuse is occurring. And the same should happen with an order through the sheriff courts. I think it's important that a child can request and get that kind of protection for its parent, especially if it is aware that that abuse is happening. I don't intend to press these amendments at this stage. I would very much wish that the Cabinet Secretary would discuss what I am trying to achieve, because I believe there is a gap in this legislation. And, you know, the last thing I want is for us to be going back, and this seems to happen every time we pass domestic abuse legislation, we realise there's a gap, and back we go to fill that gap. And there is a huge amount of domestic abuse legislation, and it's very piecemeal. So I would request some discussions with the Cabinet Secretary around this, but withdraw these amendments, and we'll probably bring them back at stage 3.
Thank you, Rhoda. So Rhoda Grant wishes to withdraw Amendment 46. Are members content that Amendment 46 be withdrawn? Members are content, and we move to the next group. And I call in that group Amendment 6 in the name of the Cabinet Secretary and a group on its own. Cabinet Secretary to move and speak to Amendment 6.
Thanks, Convener. I'll speak to Amendment 6 lodged in my name. Essentially, this amendment strengthens the requirement which must be met before a domestic abuse protection notice is imposed under Section 4 of the bill. Members know Section 4 provides for a system of notices, which are, as we say, very short-term protective measures designed to keep a person safe from the immediate risk of domestic abuse. Given the nature and purposes of notices, it is critical that an appropriate balance is struck between the immediacy with which the need for such notices may arise, and of course the procedural requirements that are placed on the police before a notice is imposed. If the procedural requirements for making a notice are unduly burdensome, then this may lead to delays in securing protection. In some cases, it could compromise the aim of providing immediate protection for those that are at risk of domestic abuse. Equally, the procedural requirements, especially in respect of views from those parties directly affected by a notice, should be sufficient to effectively inform the decision-making by the police. If the bill is introduced, Section 4.3 requires the police to, amongst a number of other matters, take into account any representations made by person A and any views of person B before making a decision to impose a notice. We have considered carefully whether the procedural requirements in this area should be clarified and made stronger, and that's exactly what Amendment 6 do. Amendment 6 seeks to replace the current requirements outlined above and instead place an explicit responsibility on the police to take such steps as are reasonable in the circumstances to establish whether person A and person B have any views in relation to the notice which they wish to be taken into account. If they do, then obtain those views. There is a requirement for the senior constable to take into account any such views before making a DAPN. I think the new provision proposed in Amendment 6 strikes a better balance in strengthening the procedural requirements, which will help inform decision making, whilst acknowledging these are very short-term notices used in cases where the immediate risk of harm needs immediate action. In particular, the police will have responsibility to take such steps as are reasonable in the circumstances. Exactly what will be reasonable will depend on each situation, and it would be, in our view, unhelpful to be more prescriptive than requiring the police in each situation to assess what steps may be reasonable in the circumstances. I consider Amendment 6 as sensible and pragmatic and improves the requirement falling on the police before which they can make a domestic abuse protection notice, and that will help to strengthen the decision-making process, and therefore would ask members to support it.
Thank you, Cabinet Secretary. No members indicated that they wish to take part in the debate on this group. So can I invite the Cabinet Secretary to wind up if he's anything further to say and to press Amendment 6?
I'm happy to press the Amendment 6 in my name.
Thank you. So the question is that Amendment 6 be agreed. Are we all agreed? We are agreed. The question is that Section 4 be agreed to. Are we all agreed? We are agreed. And we move to the next group. And in that group, I call Amendment 7 in the name of the Cabinet Secretary group with Amendments 8, 9, 23 and 24. So I invite the Cabinet Secretary to move Amendment 7 and to speak to all amendments in the group. Cabinet Secretary.
Thanks, Convener. I will speak to Amendments 7, 8, 9, 23 and 24. Amendment 7 responds to concerns expressed by Police Scotland that a suspected perpetrator could seek to frustrate the system of notices and orders by failing to comply with a request under Section 6.4 of the Bill to provide an address at which they can be notified with details of the hearing, which must be held when a DAPN has been given. Amendment 7 gives discretion to the police to decide whether to make it a requirement of the notice for person A at the time the notice is delivered to either provide an address at which person A can be notified with the details of the hearing, or undertake to provide such an address within a specified time, or to attend a specified police station at a specified time for the purpose of being given the notice of the hearing. Person A would then be required to comply with any undertaking given. The purpose of this discretion requirement of a notice is to allow the police to assess whether it's necessary to make use of this requirement to ensure notice of the hearing for an order can be given in each case. If the police decide to use the requirement and person A fails to comply without reasonable excuse, then an offence is committed under Section 7 of the Bill. Amendment 8 is consequential. It provides that unlike other requirements of a notice, effect when the notice has been given to person A, any requirement introduced by Amendment 7 only takes effect at the point when person A fails to provide an address when asked by the constable giving the notice. Amendment 9 is consequential and provides what is meant by the word specified in Amendment 7. Amendments 23 and 24 are also consequential, and they adjust references to the responsibilities of the Chief Constable to give person A notice of the hearing to be held when a DAPN has been issued. The changes reflect the different ways in which a notice might be given by virtue of Amendment 7, and I move Amendment 7 in my name.
Thank you very much. And again, no member has indicated that they wish to speak in the debate on this group. So, Cabinet Secretary, do you wish to press Amendment 7?
Pressed, Convener.
Thank you very much. The question is that Amendment 7 be agreed to. Are we all agreed? We are agreed. I call Amendment 8 in the name of the Cabinet Secretary, already debated with Amendment 7. Cabinet Secretary to move formally.
Moved, Convener.
Thank you. The question is that Amendment 8 be agreed to. Are we all agreed? We are agreed. And we move to the next group. I call Amendment 10 in the name of Rhoda Grant, in a group on its own. Rhoda Grant to move and speak to Amendment 10.
Thank you, Convener. I move Amendment 10. This amendment is to make it clear that the domestic abuse protection notice takes precedence over any other orders that are in place. It would not be ordinary for a notice issued by the police to take precedence over a court order. Therefore, this amendment makes it clear that it has precedence in these specific circumstances where the threat of abuse is immediate until it can be considered by the court. Clarifying this position explicitly on the face of the bill is something the committee recommended at stage 1. It ensures that there is no doubt for those subject to a notice who already have another order in place, or anyone issuing and enforcing a notice as to the situation in relation to the other rights and orders that may be in place. The amendment only applies for a short period of time until the notice of the court. At that time, existing orders can be amended by the court to ensure the correct protection is in place.
Thank you, Rhoda. No member has indicated that they wish to speak in the debate on this group, so can I call the Cabinet Secretary?
I thank Rhoda Grant for bringing this amendment forward. Amendment 10, lodged by Rhoda Grant, adds a new provision, Section 5 of the bill, to make clear that any prohibition or requirement in a DAPN must be complied with, notwithstanding any existing court order, which makes contrary provision. The issue was aired quite extensively during stage 1 scrutiny, and I know it was certainly I was questioned on it during my oral evidence session. One of the examples given during scrutiny was child contact orders. The DAPN is a very short-term protective order for a person at risk of domestic abuse, and it is appropriate, in my view, that the police have the powers to prohibit the person subject to the DAPN from approaching or indeed contacting a child, usually living with a person at risk. The effect of a contact or residence order is always subject to other lawful measures that may be taken in relation to a child. As I said in my stage 1 evidence of the bill, my view is that it is a criminal offence to breach any provision in a DAPN without reasonable excuse. The fact that, for example, a contact or residence order was in effect would not change this. However, having considered Rhoda Grant's amendment, I agree that it may be useful to put this matter on the face of the bill solely for the avoidance of doubt. So I support the intention behind the amendment, but there are some technical issues with it. The mechanism through which the bill requires the measures imposed by a DAPN to be complied with is the creation of an offence. We would prefer to find a way to express the desired position that works with the mechanism rather than cuts across it by introducing a separate reference to the measure requiring to be complied with. We also wish to further check that a broad reference to any pre-existing court order will not have any unintended effect. So on that basis, I wonder if Rhoda Grant would withdraw Amendment 10 at this time. I'll commit to working with her ahead of Stage 3 to deliver her policy intent, which I am sympathetic to, in a Stage 3 amendment.
Thank you, Cabinet Secretary. Rhoda Grant?
I welcome the Cabinet Secretary's support for the intention behind the amendment, and I am willing to withdraw the amendment at this time to work further ahead of Stage 3.
Thank you very much. Rhoda Grant wishes to withdraw Amendment 10. Are members content that Amendment 10 be withdrawn? Members are content. I call Amendment 9 in the name of the Cabinet Secretary, already debated with Amendment 7. Cabinet Secretary to move formally.
Moved, Convener.
That's moved. Thank you. The question is that Amendment 9 be agreed. Are we all agreed? We are agreed. And the question is that Section 5 be agreed to. Are we all agreed? We are agreed. I call Amendment 11 in the name of the Cabinet Secretary, already debated with Amendment 5. Cabinet Secretary to move formally.
Moved, Convener.
Thank you. The question is that Amendment 11 be agreed to. Are we all agreed? We are agreed. I call Amendment 12 in the name of the Cabinet Secretary, already debated with Amendment 5. Cabinet Secretary to move formally.
Moved, Convener.
Moved. So the question is that Amendment 12 be agreed to. Are we all agreed? We are agreed. The question is that Section 6 be agreed to. Are we all agreed? We are agreed. And the question is that Section 7 be agreed to. Are we all agreed? We are agreed. We move to the next group, which concerns other agencies to be able to apply for domestic abuse protection orders. I call Amendment 29 in the name of Liam Kerr, grouped with amendments as shown in the groupings. Liam Kerr to move Amendment 29 and speak to all amendments in the group.
Thank you, Convener. Good morning, colleagues. Amendment 29 introduces the concept of a supporting agency to the bill before Section 8. A supporting agency will be one that has appropriate training to deal with cases of domestic abuse. Now, the Scottish Government already works with various domestic abuse agencies and has a clear understanding of organisations who have that appropriate training to deal with such cases. So this amendment would allow these supporting agencies to apply for a domestic abuse protection order. Under the bill's current provisions, only the police are able to make such an application. And in their written submission, Police Scotland stated that they thought it was prudent to extend this power to other agencies who have experience dealing with domestic abuse cases. They noted that not only did these agencies have more expertise on the matter, but it would reduce the burden of work that the police are obliged to conduct under the bill's current terms. Now, Scottish Women's Aid were also supportive of the idea of allowing relevant agencies to apply for a domestic abuse protection order. And I've set it so that regulations setting out which agencies can be included in this bill are subject to the negative procedure. My amendments 30, 31, 32, 33, 35, 36, 37, 38, 42 and 43 introduce the provisions of the supporting agencies into the appropriate areas of the bill, such that the police and supporting agencies are able to apply for domestic abuse protection orders. These amendments ensure that the appropriate obligations upon making an application for a domestic abuse protection order apply to supporting agencies. Thank you.
Thank you, Liam. No other member has indicated that they wish to speak in this debate, so can I call the Cabinet Secretary, please?
Excuse me, and the other amendments in this group lodged by Liam Kerr. At present, the bill does empower the police to be able to apply for a DAPO, but no other agency or indeed organisation. I know this was an issue, as Liam Kerr referenced, has come up on a number of occasions during your own consideration as a committee on this bill. It is a power that I am very sympathetic to. The other amendments in this group are all consequential. Amendment 29 adjusting provisions of the bill to reflect the existence of the regulation making power. Again, I reference your stage 1 report where you indicated that the majority of evidence heard by the committee supported the police as the appropriate body to apply for a DAPO. Also, and I quote the committee again, the committee also heard evidence that future consideration could be given to broadening out the scope of those who can apply for DAPOs, but only in the circumstances where such bodies are properly resourced so as to avoid unintended consequences. And I listened carefully to what Liam Kerr had to say about training, and I wish to address that issue too. I consider that there is merit in future-proofing the legislation so to allow other bodies possibly to be added to the list of those who can apply for a DAPO. I think we do have to ensure that there is the appropriate training. We know how much training Police Scotland have had in relation to domestic abuse, and therefore it would be incredibly important that any other body that had the power to apply for a DAPO was also well trained and appropriately resourced as well. At this point, though, I will be asking Liam Kerr not to move his amendments. I will commit to work with him ahead of stage 3 to develop suitable amendments. The reasons for this is to allow some consideration about how we best future-proof through adding a regulation-making power. I think a regulation-making power is the right way to do it. However, I may be the first Cabinet Secretary in history to suggest that actually the scrutiny should be strengthened. I don't think it should be done via negative procedure as proposed in Amendment 29, given the importance and the issues that have to be considered. I think it would be better for that to be an affirmative procedure. That would give greater chance for Parliament to scrutinise and be reassured that any bodies that were being added were fully ready to take that responsibility in terms of the training, the resource, and all the other matters that I have discussed. There's also some technical deficiencies about how the regulation-making power has been added to the bill, which I don't necessarily need to go into detail here. But what I would do then is therefore ask Liam Kerr to withdraw his amendments, very sympathetic to what he's trying to achieve, and if we can work together ahead of stage 3 to develop suitable amendments that can deliver the policy intent as both he and I would like.
Thank you, Cabinet Secretary. Rhoda Grant has indicated that she wishes to speak in this debate. Could I just remind members that really members should try and speak in debates before the Cabinet Secretary responds, so that the Cabinet Secretary can respond to all of the points made in the in the debate, but I will call Rhoda Grant and then I'll call Liam Kerr. Rhoda.
Making a substantive point, just simply to say that I support these amendments, and I think it will be really important for organisations such as Scottish Women's Aid to have this ability, because on many occasions they know an awful lot more about domestic abuse than the police and might be the first port of call for victims.
Thank you, Rhoda. So can I invite Liam Kerr to wind up and to press or withdraw Amendment 29? Mr. Kerr.
Thank you, Convener, and thanks to both the Cabinet Secretary and Rhoda Grant for both contributing to the debate, but also for acknowledging that they are sympathetic to what we're trying to achieve here. I do recognise, Cabinet Secretary, that there are challenges around the training and the resourcing in particular, but I listened carefully and favourably to the Cabinet Secretary's commitment to work to develop to ensure that this is future-proofed. And I also acknowledge his comments and those of Scottish Women's Aid, who sent us a briefing last night around perhaps the challenges with the negative procedure that I've initially put in. So I'm pleased to confirm that I will withdraw Amendment 29 and my others, but I do look forward, Cabinet Secretary, to working together to deliver the policy intent that I think we all want to achieve. So I will withdraw Amendment 29, Convener.
Thank you, Liam. So Amendment 29 is not pressed. Mr. Kerr seeks to withdraw it. Are members content that Amendment 29 be withdrawn? Members are content. I call Amendment 30 in the name of Liam Kerr, already debated with Amendment 29. Liam Kerr, to move or not move?
Not moved, Convener.
That's not moved. Thank you. I call Amendment 47 in the name of Rhoda Grant, already debated with Amendment 46. Rhoda Grant, to move or not move?
Not moved.
That's not moved. Thank you. And we move to the next group. And I think, colleagues, can I just say, if we maintain this pace, I think we can be optimistic that we can complete stage 2 considerations today. But I do intend to take a short pause, but no more than 5 minutes after this group, just to enable members to take a comfort break. But we'll move to the next group before taking a pause. And I call Amendment 13 in the name of the Cabinet Secretary, grouped with Amendments 15, 16, 20 and 21. Cabinet Secretary, to move Amendment 13 and speak to all amendments in the room. Cabinet Secretary.
Convener, thank you. I'll speak to Amendment 13, but also to Amendments 15, 16, 20 and 21 lodged in my name. I will confess, Convener, these are probably the group of amendments and the substantial amendment that I wrestled with the most. I think they deal with a particularly sensitive issue around coercive control. Amendment 15 is the substantive amendment. It provides that consent from person B is required before a domestic abuse protection. Is a new requirement which has been developed following discussions with Scottish Women's Aid and indeed listening to the evidence that the committee heard through stage 1 consideration. A number of those who gave evidence during stage 1 scrutiny, including Scottish Women's Aid, made clear that they view the system of orders as being about protection for a person at risk of domestic abuse, so that the person themselves can be empowered to make their own decisions about their future situation. I do agree with this, and this is how the system was envisaged. However, Scottish Women's Aid have indicated, both direct to the Scottish Government and to the committee, that to ensure the person at risk is fully empowered to make decisions about their own situation, their consent should be required for the making of a full DAPO. In particular, Scottish Women's Aid suggests that if by the time a court is considering an application for an order, the person at risk has not given their consent, then it would not be appropriate or potentially proportionate for an order to be imposed. The committee acknowledged in its stage 1 report that it may be difficult for the person at risk to provide consent because of the issues around coercive control, which we all know and understand. The amendments do not change that consent is not required for the making of a DAPN. In addition, Amendment 21 adds provision to Section 10 to make clear that consent is not needed for an interim DAPO to be made. Decisions in any given application for an order, of course, will always be for the Sheriff to determine. Depending on the precise circumstances of an application, the Sheriff will have the ability to decide to provide the person at risk with some time away from the suspected perpetrator to fully consider their situation by making an interim order. Scottish Women's Aid consider that any such time away that can be provided has the potential to be key in obtaining consent to the making of a full order. If consent is not given because it's simply the view of the person at risk that the order would not be beneficial to them in their own specific situation, then the view of Scottish Women's Aid is that the court should respect that and not impose an order against their wishes. Amendment 13 is a technical amendment paving the way for Amendment 15. Amendment 16 is a minor consequential amendment reflecting changes in structure and numbering. Amendment 20 is consequential Amendment 15 and removes the current provision indicating consent is not required. Convener, this is clearly a very sensitive and important area of the bill. I've listened to the arguments put forward and have reached a finely balanced view that consent for a full order should be required, but only for a full order. I offered views in my evidence at stage 1 to the committee that coercive controlling behaviour could result in consent being withheld. However, I am satisfied that these amendments strike the appropriate balance by providing some flexibility when DAPNs and interim DAPOs are being considered, but very much respecting persons B autonomy by making consent a prerequisite for a full DAPO. It should be remembered that if there is sufficient evidence that person A is using tactics of coercive control to prevent or inhibit person B from providing consent to a DAPO, the appropriate route would be for the police to report this to the Crown for consideration of prosecution. I therefore move Amendment 13 in my name.
Thank you very much, Cabinet Secretary. John Finney has indicated that he wishes to speak in the debate on this group, so I call John Finney.
Thank you, Convener. Yes, I agree with the Cabinet. This is a particularly sensitive aspect. The the controlling and coercive behaviour that was included in the Domestic Abuse Act, an important element of that was the training that would be required by not simply the police, but also legal services to appreciate the very nuanced abuse that it was trying to address. I wonder if the Cabinet Secretary can comment on these discussions with the police. I would envisage that the training programme has been rolled out, but in the discussions with the police, if you like, the time between the granting of a notice and the application for an order, whether it's likely that the police would be deploying their specialist domestic violence staff to deal with that, who would perhaps have more regular cause to have an understanding of coercive and controlling behaviour, if that featured in the discussions. It's not to be in any way disparaging to any officer at all, but we know that if you're regularly dealing with something, and these are the people who, for instance, in many cases that Scottish Women's Aid would be dealing with, if that's been a feature of the discussions, because this is potentially very tight timeframes when a lot of important decisions have to be made, but it is about respecting the individual's wish, but not allowing any suggestion of coercive and controlling behaviour to have influenced any decision regarding application for an order. So if the Cabinet Secretary can perhaps comment on any discussions he had with the police about the application of that particular sensitive issue in that very potentially tight timeframe, please.
Thank you, Mr. Finney. No other member has indicated that they wish to speak in the debate on this group, so can I invite the Cabinet Secretary to respond to that and to wind up and press or withdraw? Cabinet Secretary.
Yes, can I thank John Finney for an incredibly important question. I think I would make two substantial points. One is, as you may be aware, after the passing of the Domestic Abuse Act, police officers undertook extensive training on domestic abuse. In fact, 14,000 officers were given that extensive specialist training in relation to domestic abuse, which I can confirm did include issues around coercive control. So the vast majority of our police officers, 14,000 on the front line, have had that extensive training. In terms of the operational matters that he discusses, they are of course operational matters, but what I can do, if it gives a further degree of reassurance to John Finney, he'll note in my response to the Stage 1 report, I talked about an implementation board, which would include Police Scotland obviously as key members of that implementation board, and I will raise that issue. Sorry, as a final reassurance, I should say, to John Finney, just to make it absolutely clear, we are talking about requiring consent for a full DAPO. My amendment would not change what is currently in the bill around a DAPN or an interim DAPO. So hopefully that taken together gives John Finney some element of reassurance.
Thank you, Cabinet Secretary. So I think the question is that Amendment 13 be agreed to. Are we all agreed? We are agreed. I call Amendments 14, 15, 16 and 17, all in the name of the Cabinet Secretary and all previously debated. And I invite the Cabinet Secretary to move Amendments 14 to 17 en bloc.
Convener, moved en bloc.
Thank you. Does any member object to a single question being put on Amendments 14 to 17? No member objects, so the question is that Amendments 14 to 17 are agreed to. Are we all agreed? We are agreed. I call Amendment 31 in the name of Liam Kerr, already debated with Amendment 29. Liam Kerr, to move or not move?
Not moved.
That's not moved. I call Amendment 32 in the name of Liam Kerr, already debated with Amendment 29. Liam Kerr, to move or not move?
Not moved.
Not moved. I call Amendment 33 in the name of Liam Kerr, already debated with Amendment 29. Liam Kerr, to move or not move?
Not moved.
That's not moved. We've reached the next group, colleagues, and what I will do now is to suspend just for 5 minutes to enable members to take a comfort break, and we will reconvene at 1 or 2 minutes past 11. Many thanks, everyone. Welcome back. We move straight to the next group, which concerns making an extension of domestic abuse protection orders. And I call Amendment 18 in the name of the Cabinet Secretary, grouped with Amendments 18A, 19, 25, 25A, and 39. Cabinet Secretary to move Amendment 18 and speak to all amendments in the group.
Thanks, Convener. I will now speak to Amendment 18 and the other amendments in this group. I know we were making good pace, but I hope you and committee members will forgive me that I'll take some time over the amendments that are in this group. Amendment 18 and 25, they are a proportionate response to the Stage 1 report recommendation about Section 8.6D of the bill, which requires the Sheriff, in considering whether to make any provision in an order which would relate directly to a child, take into account any views of the child of which the Sheriff is aware. But the recommendation from the committee was to, and I quote, ensure that the provisions in this bill are consistent with the Children's Scotland Act 2020 and other relevant legislation. Convener, it's important to note that a fundamental difference between the Children's Scotland Act 2020 and the protective order scheme in the bill is that the specific court proceedings which are affected by the provisions in the 2020 Act relating to the views of children include cases such as contact and residence disputes, adoption, permanence cases, and children's hearing cases. Proceedings of this nature are inevitably always going to directly affect the children to whom they relate to. In contrast, DAPNs and DAPOs are concerned with protecting persons aged 16 or older from the risk of domestic abuse, and they will or may not contain provisions directly relating to a child. A DAPO can make provision relating to a child, but can do so only where this is necessary for the purpose of protecting the person at risk. As members know, and as I've stressed throughout this session, DAPNs and DAPOs are short-term emergency notices and orders. As such, I'm not persuaded that adopting in its entirety the approach taken in the Children's Scotland Act 2020 would be appropriate. I explained in an earlier grouping that there requires to be a careful balance struck between acknowledging the rights of children to be heard effectively with the constraints of a scheme designed to react swiftly, quickly to adults at risk of domestic abuse. I think it's important to reflect on the words of the committee's Stage 1 report. Paragraph 247, the committee were clear, and again I'll quote, the legislation must work in practice if it is to be effective, even if it is only used, as the police said, in exceptional circumstances. Passing legislation that cannot easily be used will not help victims of domestic abuse. On balance, I'm persuaded that a proportionate response to this area is that there should be a duty on sheriffs to take such steps as are reasonable in the circumstances to give the child an opportunity to express views where the sheriff is considering making provision in an order which could directly relate to a child. Amendment 18 amends Section 8 to provide for this. With regard to the question of what steps would be reasonable in the circumstances, the intention is that where it is reasonably possible for the sheriff to give the child an opportunity to express views in the time available before making a DAPO, that this should be done. However, where this cannot reasonably be done before making a DAPO, this would not mean that the sheriff is prohibited from making provision directly relating to a child where this is necessary for the purpose of protecting the person at risk of domestic abuse. The sheriff is then obliged to take into account any views of the child of which they're aware, whether as a result of the steps taken to give an opportunity to express their views or otherwise. In taking account of the views of the child, the sheriff must take into account the child's age and indeed the child's understanding. Amendment 25 makes equivalent provision where the sheriff is considering an application to extend, vary or discharge a DAPO. Turning to Amendment 19 in the name of Rhoda Grant, this amendment also seeks to address the concerns expressed by the committee about how the views of children can be considered by the court. It creates a duty on the sheriff to provide an opportunity for the child to give their views in a manner of their choosing, or in a manner that is suitable to the child, if the child has not indicated a preference, or it would not be reasonable in the circumstances to accommodate the child's preference. This would apply in any case where the sheriff considers there is a child whose interests are relevant to the making of an order, or where the sheriff is considering making provision in an order which would directly relate to a child. I do have sympathy with the intent behind this amendment. However, I'm deeply concerned that placing an absolute requirement on a sheriff to seek the views of a child in every case where they are considering the matters at section 863 and D of the bill carries a serious risk of unintended consequences. As members will be aware, court decisions relating to, for example, child contact and residence, they can take a considerable amount of time to be determined by the courts. By contrast, and as the committee supports, DAPOs are short-term emergency orders intended to protect somebody at immediate risk of domestic abuse. They require to be made, as per the legislation, very quickly. The maximum time that an interim order can run for before a decision on the substantive order is 3 weeks. Obtaining views from children on a sensitive matter such as allegations of domestic abuse concerning their parents has to be done sensitively, professionally, by people with expertise in doing so. For this reason, I think it's important that the sheriff is able to consider whether it is reasonable to seek the views of a child as per my Amendment 18, rather than the absolute requirement in Amendment 19. Taking account of all the facts and circumstances of the cases before them, including the time frame within which a decision about a DAPO has to be made. This should provide a certain level of flexibility and ensure that DAPOs can still be made where necessary for the protection of a person at risk, even if it has not been possible within the time frame to give the child an opportunity to express their views. Amendment 39 makes an equivalent change to the provision concerning variation, detention and discharge of DAPOs, and I have the same concern about that amendment and prefer my Amendment 25 as giving a proportionate response to the concerns of the committee. Turning to Amendments 18A and 25A in the name of Rhoda Grant, I understand that these have been lodged as an alternative to Amendments 19 and 39. These amendments, which would amend my Amendments 18 and 25, seek to introduce a presumption that a child is capable of expressing a view in relation to making a DAPO. They would also give the child the opportunity to express the child's view in a manner the child prefers, or in a manner that is suitable to the child if the child has not indicated a preference. These amendments would not place the same inflexible additional burden on the courts that Amendments 19 and 39 would. However, as I've explained, we have had to balance very carefully the importance of seeking the views of children in appropriate cases with the need to ensure that the system we put in place is flexible and manageable enough to work as a means of quickly determining applications for emergency orders. It's not clear, for example, what would be required for the sheriff to override the statutory presumption that a child is capable of expressing a view in the making of a DAPO. And I think we'd all recognise that there will be some children who, for example, because of their very young age, are not capable of offering a view on the making of a DAPO. In a situation where the court requires to obtain the views of a child very quickly, it may not always be realistic to establish, for example, the child's preferred manner of giving evidence. To conclude, I have concerns that Amendment 18A, 19, 25A and 39 would place further inflexible burdens on the court in cases which can be complex and which require them to make decisions quickly. As such, while I absolutely sympathise with Rhoda Grant's motives in lodging these amendments, I'd ask members to support my Amendments 18 and 25 and reject Amendments 18A, 19, 25A and 39.
Thank you, Cabinet Secretary. Can I ask Rhoda Grant to move Amendment 18A and to speak to all the amendments in the group? Rhoda.
I move Amendment 18A and speak to the others in the group. My amendments in this group seek to strengthen the manner in which children's views are taken into the sheriff looking to put in place a domestic abuse protection order. Children, as I've said before, are detrimentally impacted by domestic abuse, and it's important that they are reassured through the process and have their views taken into account. Given those hearings could be potentially traumatic, the more protections in place for children, the better. Amendments 19 and 29 lift provisions for taking the views of children from the Children Scotland Act 2020, which were considered and agreed by the Justice Committee only a short time ago. For that legislation, the committee considered how the views of a child should be taken into account by a court in considering disputes between parents. The committee determined that in these situations it should first be presumed that the child had a view and that the court should allow children an opportunity to express these views in a manner that they preferred. And I see no reason why that principle should not also apply here. I believe we all wish to ensure that in such important circumstances, children's views are sought in a manner that is suitable for them. As similar language has been used for recent law, these amendments keep a level of consistency for courts in their approach to taking the view. Well, I was in the process of drafting these amendments when the Cabinet Secretary tabled 18 and 25, which attempt to do the same thing. But I believe the Cabinet Secretary's amendments don't go far enough. The requirement to seek children's views is not as strong and leave too much to the subjective decision of the sheriff. I tabled amendments to the Cabinet Secretary's amendments. These are 18A and 5A, which would include the important presumption in favour of a child's ability to form an opinion. The requirements to appropriately seek those opinions within the Cabinet Secretary's amendment bring them more into line with the Children's Scotland Act 2020. My preference would be for the committee to agree my amendments 19 and 29 because they are less ambiguous. However, I have also lodged the amendments to the Cabinet Secretary's amendments, which I hope would strengthen them and bring them into line with the Children's Scotland Act 2020. As I've said before, children are not bystanders. They are damaged by domestic abuse and they need to have their views taken into account. We all know that sheriffs are not always experts in domestic abuse, quite often don't understand its implications, and we see that day and daily in our constituency casework where custody orders have been sought to perpetrate domestic abuse and sheriffs agree then, leaving both victims and their children in danger. So I would ask the committee to back the strengthened amendments to allow children's views to be taken into account.
Thank you, Rhoda. John Finney has indicated that he wishes to speak in the debate in this group, so I call John Finney, please.
Okay, thank you, Convener. And I'll perhaps personally return to practical matters, because I always want to understand what the implications are. And Rhoda's entirely right to talk about consistency of approach and the value that should be placed on children's views. And it's entirely right to say they are damaged by domestic abuse. I'm trying to think of the time frame for this. If we're talking about an order, I can see how with a longer term, so an extension of an order, there is the possibility. I can't imagine anything that would traumatise a child more than perhaps being removed from their bed in the early hours of the morning to try and give an explanation to inform a decision. That in itself is potentially abusive. Now, I know that that's not the approach anyone wants to take, but we have to try and understand the practical effect of things. And in an ideal world, there's time for reflective consideration, there's time for it to be done in an appropriate way. And we know that all children are individuals, they all have different ways of seeing things and different ways that would be happy to relate what they have seen. I have concerns about this, not about the intention. I don't doubt for a second that Rhoda wants to make things better and wants informed decision making. I'm just not convinced it can work in practice with the immediacy, which is all about what this is all about, an immediate response to an emergency situation. Perhaps Rhoda would want to comment on that. Thank you.
Thank you. Thank you very much, Mr. Finney. I'm going to invite the Cabinet Secretary to wind up first and then Rhoda Grant to wind up as a whole and to press or withdraw Amendment 18A. But Cabinet Secretary first, please.
Thank you, Convener. And just on that latter point made by John Finney, I think that is where I would really emphasise my remarks. I don't think anybody would question Rhoda Grant's motives or intentions behind her amendments, and she has spoken well and articulated well often during debates on domestic abuse, as she has done today, the importance of children and the effect that domestic abuse can have. And we all recognise that. I don't think there's a single committee member who takes a contrary view to that. However, my concern is the fact that an unintended adverse consequence of Rhoda Grant's amendments could be to actually derail ADAPO because of the really tight time frame of a potential protective order. It could end up meaning that because of this inflexible approach, that if a child's views cannot be taken and within that time frame, even if they were scheduled at a particular evidence suite, for example, to give evidence or left to give evidence to give their views in a very sensitive manner, but for whatever reason they were unable to attend on that day and another date could not be scheduled, then would that mean that a DAPO would then have to be derailed? A sheriff could not bring forward a DAPO even if they believe that person to be at risk. And that is the danger, I think, of an inflexible approach. And that's why I would request that members support my amendments, which I move in my name. And if Rhoda Grant presses her amendments, then I hope members will reject them for that reason.
Thank you very much, Cabinet Secretary. So Rhoda Grant to wind up and press or withdraw Amendment 18A. Rhoda.
Yep. Just with reference to John and his concern, my amendments don't aren't in place for the notice. So therefore, this wouldn't be done during the night that children would be taken out of their beds and asked for their opinions. The clause in my amendment states that the child's views would be taken in a manner that is suitable to the child if the child has not indicated a preference, or it would not be reasonable in the circumstances to accommodate the child's preference. So if there is still a get-out clause within my amendments, although they strengthen what the Cabinet Secretary are saying, they do not insist that it is the way the child prefers, but that the child's view taken. So I believe it is reasonable, and I believe it puts in a protection for children that the Cabinet Secretary's amendments do not.
So is it your intention, Rhoda, to press Amendment 18A?
Yes, press Amendment 18A.
Okay, so thank you. So that is pressed. The question is that Amendment 18A be agreed to. Are we all agreed? We're not agreed, and there will be a division. So can I invite all members of the committee in favour of Amendment 18A to type Y into the chat box now, please? Can I invite all members of the committee opposed to Amendment 18A to type N into the chat box now, please? And can any member wishing to abstain on Amendment 18A please type A into the chat box now? The result on Amendment 18A is that there was 1 vote in favour and 7 votes against. There were no abstentions. Those voting in favour were Rhoda Grant, and those voting against were Rona Mackay, Annabel Ewing, Jonah Robertson, Fulton McGregor, Adam Tompkins, Liam Kerr, and John Finney. The amendment is disagreed. I invite the Cabinet Secretary to press or withdraw Amendment 18. Cabinet Secretary?
Press, Mina.
Thank you. The question is that Amendment 18 be agreed to. Are we all agreed? We are agreed. I call Amendment 19 in the name of Rhoda Grant, already debated with Amendment 18. Rhoda Grant to move or not move?
Not moved.
That's not moved. I call Amendment 20 in the name of the Cabinet Secretary, already debated with Amendment 13. Cabinet Secretary to move formally?
Moved, Convener.
Thank you. The question is that Amendment 20 be agreed to. Are we all agreed? We are agreed. And the question is that Section 8 be agreed to. Are we all agreed? We are agreed. We move to the next group, which concerns the maximum period for which a domestic abuse protection order or interim order may have effect. And I call Amendment 34 in the name of Rhoda Grant, grouped with Amendments 40 and 41. Rhoda Grant to move Amendment 34 and speak to all amendments in the group. Rhoda.
I move Amendment 34 and speak to others in the group. When we took it was clear that the timeframes in the bill regarding the length of time for which an order could be put in place were short. The aim of this legislation is to fill a gap in the law whereby victims of abuse have limited recourse of protection other than civil protection orders, for which the processes are often lengthy and costly. This would be the case in normal times, but at the moment, due to the pandemic, the length of time to wait to access the courts is even longer. The concern is that the short time frames in the bill undermine the intention to fill the current gap. If orders are too strictly time limited, there is a risk that the time will run out and the victims again will be at risk of harm. Or where an immediate risk still insists, as it's likely if other protections are not yet in place, there will simply be a perpetual cycle of interim orders and notices, and this is likely to be traumatic for the victim and children. It does not prioritise their safety, and I would suggest it is not a valuable use of court and police time. In order to take this into account, Amendment 34 increases the maximum length of an order from 2 to 6 months. This time frame is proposed to reflect the evidence that the committee heard, namely that applications for exclusion orders can take up to 6 months and other civil protection orders even longer. Amendment 40 and 41 then alter the arrangements for extending an order. Amendment 40 removes the 1 month limit for extensions to limit the likely burden on courts, and Amendment 41 removes the overall maximum limit for a domestic abuse protection order, and as an alternative leaves it to the sheriff to extend an order until such time as they believe is necessary. When setting that time frame, they will know when the courts are likely to hear an application for a non-harassment order or exclusion order or the like. This means that a sheriff can determine how long an order should be in place, taking into account the specific circumstances of individual cases. If they believe that the subject of an order will not be able to get other protection, they can extend the domestic abuse protection order to provide that protection going forward. Importantly, an order would still be time limited and could not remain in effect once other suitable arrangements were in place and or protections of a DAPO were no longer necessary. Amendment 41 also retains the 3-week limit for interim orders as, in their name, these are intended to be short-lived. I commend this approach to the committee as being more practical given the reality of alternatives for victims of abuse, and for also creating a clearer distinction between the purpose of interim orders and full domestic abuse protection orders.
Thank you, Rhoda. And no other member of the committee has indicated that they wish to speak in the debate on this group, but I would just like to say, in relation to these amendments, that I recall when this set of issues was discussed by the committee at stage 1, and indeed when we took evidence on these issues at stage 1, that there were significant European Convention on Human Rights concerns raised in relation to the dangers of extending the duration either of DAPNs or DAPOs. So perhaps that is something that either the Cabinet Secretary could touch on, or that Rhoda Grant could respond to in her winding up. But I call the Cabinet Secretary.
Thank you, Convener. I will address that point at the very end of my remarks. I will speak to Amendments 34, 40 and 41. Rhoda Grant has articulated why she thinks these amendments are necessary. I know, again, members will have had the briefing from Scottish Women's Aid, and they do not support, and many of the reasons that they give for not supporting, are the very same reasons why I cannot support Rhoda Grant's amendments. I remind the committee that DAPNs and DAPOs, as I keep saying, are intended to be short-term emergency orders, or indeed, as you put it in your Stage 1 report, in paragraph 209, I quote, DAPNs may provide a useful short-term tool to be used in emergency situations to complement existing civil measures and the current powers afforded to police. As such, they're not a replacement for the longer-term civil protective orders, such as exclusion orders or indeed interdicts or non-harassment orders, which a person experiencing domestic abuse may decide to take out to address their longer-term housing situation. I'm aware that the committee heard concerns that an application for an exclusion order or interdict would not necessarily be determined by the court within 3 months. That may be true, but courts are able to grant an interim exclusion order or interim interdict much more quickly, and I'm content that the 3-month maximum time that the bill provides for is sufficient for this to happen. I do appreciate there will be cases where a person at risk's long-term plan may not be to remain in the home that they previously shared with person A, and that where, for example, they decide to sell a home they own together, this could take longer than 3 months. In these cases, it's always been the intention the person at risk would be able to seek an interim exclusion order or interdict in such a case to provide protection during this period. I am aware that committee has heard specific concerns about the situation where the person at risk's landlord has made an application for a change of tenancy to remove the suspected perpetrator from that tenancy, and that it's unlikely that this will be resolved within the 3 months that a DAPO can run for. In such a situation, the person at risk could apply for an interim interdict or interim exclusion order. However, in this very specific situation, I do accept that where there is an ongoing court action to remove a suspected perpetrator from a tenancy, then there is possible merit in avoiding the person at risk having to initiate their own court action separate from the action being taken by the landlord. So as such, I commit to give further active consideration, potentially amending the bill to enable a DAPO to be extended beyond 3 months in the very specific case where the person at risk's landlord has made an application to the court to reassign a shared tenancy. In relation to the amendments by Rhoda Grant, the very final thing I would say is in relation to the issue that you raise, Convener, and there is no doubt that there could be ECHR concerns in relation to the proportionality of a 6-month period. We are satisfied that our bill, the 3-month period, that is the absolute maximum that a DAPO could apply for, is proportionate. But there's no doubt, of course, that if you have an open-ended DAPO, which is the effect of one of the amendments from Rhoda Grant, then there would be potential consequences or questions to be raised around whether or not that is proportionate, particularly given this is an individual that has not been convicted at this stage of a crime, certainly not of a domestic abuse offence. And therefore, I hope that, while recognising the sympathy, the motive, and the intention behind Rhoda Grant's amendments, we cannot support them.
Thank you, Cabinet Secretary. Can I invite Rhoda Grant to wind up and to press or withdraw Amendment 34, please?
Thank you, Convener. I still have some concerns that 3 months is simply not long enough. But I take into account that the Cabinet Secretary has offered further discussion, albeit on very specific points about extending those orders, and therefore I will not press my amendments at this point.
Okay, thank you. So Rhoda Grant wishes to withdraw Amendment 34. Are members content that Amendment 34 be withdrawn? Members are content. And the question then is that Section 9 be agreed to. Are we all agreed? We are agreed. I call Amendment 21 in the name of the Cabinet Secretary, already debated with Amendment 13. Cabinet Secretary to move formally.
Moved, Convener.
Thank you. That's moved. The question is that Amendment 21 be agreed to. Are we all agreed? We are agreed. And we move to the next group, which concerns DAPOs and interim orders and appeals. And I call Amendment 22 in the name of the Cabinet Secretary, grouped with Amendments 26 and 27. Cabinet Secretary to move Amendment 22 and speak to all amendments in the group.
Thank you, Convener. I will speak to Amendments 22, 26 and 27, which, as you say, relate to the issues of appeals. Amendment 27 inserts a new section into Part 1 of the bill. The new section makes clear that decisions to make or refuse to make a DAPO, and decisions to extend, vary or discharge, or refuse to extend, vary or discharge a DAPO, are decisions which are appealable under Section 110, subsection 1 of the Court Reform Scotland Act 2014, meaning that an appeal may be taken without the need for permission. It then goes on to address the fact that when a decision of the Sheriff is appealed, the general default position is that the decision is suspended until the appeal is determined. This would mean where a decision to grant a DAPO is appealed, that the order would not take effect until the appeal has been determined, unless the Sheriff Appeal Court chooses to make an order departing from that position. I think that in this case, it is preferable for the default position to be that the original decision continues in effect, unless the Sheriff Appeal Court, taking account of all of the facts and circumstances of the case, decides otherwise. This ensures that the protection offered by the making of a DAPO continues while any appeal is being considered. Subsections 3 to 5 of the new section therefore reverses the normal default position and provides that in all appeal cases involving DAPOs, the original decision continues in effect pending determination of the appeal. But the Sheriff Appeal Court, and where the appeal is remitted to the Court of Session for the decision, both the Sheriff Appeal Court and the Court of Session do have the power to override this default position and suspend the effect of the original decision. Subsections 6 to 8 set out a broadly similar position in relation to appeals to the Court of Session against the decisions of the Sheriff Appeal Court. Convener Section 15(2)(b) of the Bill provides that applications to extend, vary or discharge DAPOs or interim DAPOs under Section 12(1) should be made to a sheriff of the same sheriffdom as the sheriff who made the order to which the application relates. It does not currently cover cases when orders made by an appeal court. I don't think that it would be appropriate for applications under Section 12(1) in relation to such cases to have to involve the appeal court that made the order. So Amendment 26 therefore amends Section 15(2)(b) to ensure that all applications for extension, variation or discharge, including applications in cases where the order was made in the course of appeal proceedings, should be made to a sheriff in the same sheriffdom where the original application for a DAPO was considered. Amendment 22 is consequential to Amendment 26, and therefore I move Amendment 22.
Thank you, Cabinet Secretary. No member is indicating that they wish to speak in a debate on this group. So can I invite you to add anything you want to by way of winding up and to press Amendment 22?
Nothing to add other than confirm that I'll press the amendment. Thank
you very much. So the question is that Amendment 22 be agreed to. Are we all agreed? We are agreed. The question is that Section 10 be agreed to. Are we all agreed? We are agreed. I call Amendment 23 in the name of the Cabinet Secretary, already debated with Amendment 7. Cabinet Secretary to move formally.
Moved, Convener.
Thank you. The question is that Amendment 23 be agreed to. Are we all agreed? We are agreed. I call Amendment 24 in the name of the Cabinet Secretary, already debated with Amendment 7. Cabinet Secretary to move formally.
Moved, Convener.
Thank you. The question is that Amendment 24 be agreed to. Are we all agreed? We are agreed. The question is that Section 11 be agreed to. Are we all agreed? We are agreed. I call Amendment 35 in the name of Liam Kerr, already debated with Amendment 29. Liam Kerr to move or not move?
Not moved.
Thank you. That's not moved. I call Amendment 36 in the name of Liam Kerr, already debated with Amendment 29. Liam Kerr to move or not move?
Not moved.
Thank you. I call Amendment 37 in the name of Liam Kerr, already debated with Amendment 29. Liam Kerr to move or not move?
Not moved.
And I call Amendment 38 in the name of Liam Kerr, already debated with Amendment 29. Liam Kerr to move or not move?
Not moved.
Thank you. I call Amendment 25 in the name of the Cabinet Secretary, already debated with Amendment 18. Cabinet Secretary to move formally.
Move, Convener.
Thank you. I call Amendment 25A in the name of Rhoda Grant, already debated with Amendment 18. Rhoda Grant to move or not move?
Not moved.
That's not moved. So the question is that Amendment 25 be agreed to. Are we all agreed? We are agreed. I call Amendment 39 in the name of Rhoda Grant, already debated with Amendment 18. Rhoda Grant to move or not move?
Not moved.
That's not moved, thank you. The question is that Section 12 be agreed to. Are we all agreed? We are agreed. I call Amendment 40 in the name of Rhoda Grant, already debated with Amendment 34. Rhoda Grant to move or not move?
Not moved.
That's not moved. I call Amendment 41 in the name of Rhoda Grant, already debated with Amendment 34. Rhoda Grant to move or not move?
Not moved.
That's not moved. So the question is that section 13 be agreed to. Are we all agreed? We are agreed. I call Amendment 42 in the name of Liam Kerr, already debated with Amendment 29. Liam Kerr to move or not move?
Not moved.
That's not moved. I call Amendment 43 in the name of Liam Kerr, already debated with Amendment 29. Liam Kerr to move or not move?
Not moved.
That's not moved. The question is that section 14 be agreed to. Are we all agreed? We are agreed. I call Amendment 26 in the name of the Cabinet Secretary, already debated with Amendment 21. Cabinet Secretary to move formally.
Moved, Convener.
Thank you. The question is that Amendment 26 be agreed to. Are we all agreed? We are agreed. The question is that section 15 be agreed to. Are we all agreed? We are agreed. I call Amendment 27 in the name of the Cabinet Secretary, already debated with Amendment 22. Cabinet Secretary to move formally. Cabinet Secretary to move formally.
Moved, Convener.
Thank you. That is moved. The question is that Amendment 27 be agreed to. Are we all agreed? We are agreed. And the question is that section 16 be agreed to. Are we all agreed? We are agreed. And we move to the next group, which concerns the operation, which concerns a report on the operation of Part 1. And I call Amendment 48 in the name of Liam Kerr, in a group on its own. Liam Kerr to move and speak to Amendment 48.
Thank you, Convener. Amendment 48 seeks to introduce a reporting requirement on the Scottish ministers. This report will monitor and examine the number of domestic abuse protection notices and orders made, as well as the number of offences for breaches, both reported and the number of convictions obtained. The bill currently doesn't contain any duty to report on its operation. That, I think, is an undesirable situation, and particularly given that there is such a duty under Section 14 of the Domestic Abuse Scotland Act of 2018, it would seem to me reasonable to introduce a similar duty into this legislation. I note also Scottish Women's Aid's briefing, which suggests that monitoring is in line with identified good practice. And finally, Convener, I'm cognizant of the Law Society's thoughts that if notices and orders add to the number of existing and criminal and civil law provisions, as per paragraph 24 of the policy memorandum, then such reporting will allow scrutiny of their specific use. For these reasons, I move the amendment to hear the committee and the Cabinet Secretary's thoughts. Thank you, Convener.
Thank you, Liam. No member of the committee is indicating that they wish to speak in a debate on this group, so I call the Cabinet Secretary, please.
Thank you. Thanks to Liam Kerr for lodging his amendments. It is the intention of the Scottish Government to ensure that information and data is made available about the operation of the new powers contained within the bill. That can help inform Parliament and help inform the Government when it comes to future policy, and of course to assess the effectiveness of the legislation that we hopefully will pass. I'm aware in recent years it's become more common to include that reporting requirement on the face of legislation. So on that basis, I accept the principle of the amendment, but I would ask Liam Kerr not to move it at this stage, but instead commit to work with the Government ahead of Stage 3 to develop an agreed approach. I think the reasons why I consider that would be preferable is that we should just take some time between Stage 2 and 3 to assess what best could be included in any reporting requirement. What is it that we want? What information is it that we need to help deliver useful information to us on the effectiveness of the legislation? Some of that information may be very similar to what is proposed in Amendment 48. For example, the number of notices and orders imposed. I think that's reasonably sensible. But I consider it would be advantageous to assess whether all of the information is strictly needed and crucially is also capable of being delivered by criminal justice agencies. In addition, the requirements of Amendment 48 seem very focused on data. I do think the data is, of course, important, but also we should recognise that effectiveness of outcomes is also really important, and therefore we may require qualitative research to be undertaken, for example, with people for whose protection DAPOs have been made, rather than necessarily just statistical binary data, for example, the numbers of DAPOs that have been made or which have been breached. So I suppose on that basis, I would ask Liam Kerr not to move Amendment 48 with the agreement that I commit to work with him ahead of stage 3, develop an agreed amendment that delivers a policy intent of being both meaningful but also deliverable in terms of a reporting requirement.
Thank you very much, Cabinet Secretary. I invite Liam Kerr to wind up and to press or withdraw.
Yeah, thank you, Convener, and thank you to the Cabinet Secretary. I think that entirely makes sense. It does make sense to ensure that data can be collected from the agencies, and it entirely makes sense to consider whether we do actually need some extra information. Have I correctly captured everything that needs to be captured in such a report? So I'm persuaded by the Cabinet Secretary's representations there, and I'll be pleased to work with him before stage 3 to ensure that what we ultimately produce is both meaningful and deliverable. So for those reasons, Convener, I shall withdraw that Amendment 48.
Thank you very much. Drawn. Members are content. So the question is that section 17 be agreed to. Are we all agreed? We are agreed. And we move to the next group, which concerns termination of Scottish secure tenancies. And I call Amendment 49 in the name of Rhoda Grant, grouped with Amendments 50 and 51. Rhoda Grant to move Amendment 49 and to speak to all amendments in the group. Rhoda.
I move Amendment 49 and speak to 50 and 51 as well. Amendment 49 aims to protect victims from landlords who could move to evict while what they see as problematic tenants. There are often antisocial behaviours that can be linked to domestic abuse cases, things like rent arrears, drag or alcohol misuse, and the like. When proceedings have already been raised by landlords against tenants subject to action, this amendment aims to give the victims some breathing space while dealing with the fallout from that action. This provision would apply irrespective of the grounds for recovery of possession that the landlord sought to rely on, as it's impossible to know how the impact of domestic abuse could actually be manifesting itself. Pausing proceedings would allow the victim to get support to deal with those issues that were a cause for concern. Amendment 50 allows for victims' tenancies to be regarded as a new tenancy rather than a continuing tenancy. This means that if there were rent arrears, the victim is not left solely liable for these. These rent arrears could then be sought from both victim and the abuser separately, and the victim can begin afresh without the burden of the past affecting their home. Amendment 51 ensures that if a victim is not at risk of losing their home themselves, it should not be left solely to the landlord to decide, as unscrupulous landlords could use the action as an opportunity to get all tenants out of the property, and there is no duty upon them to provide alternative accommodation. This amendment adds the requirement that the victim will be offered a tenancy.
Thank you, Rhoda. No other member is indicating that they wish to speak in a debate on this group, so can I call the Cabinet Secretary, please?
Thank you, Convener. Excuse me. I will speak to Amendments 49 to 51 in this group lodged by Rhoda Grant. I believe that one of the intentions excuse me, of Amendment 49 is to help address the issue of coerced debt, where rent arrears have been accrued as a result of financial abuse and coercive control. I recognise the importance of providing domestic abuse victims with that tenancy support, including payment of rent or managing rent arrears which have accrued prior to a transfer of a tenancy and the ending of a perpetrator's interest in the tenancy. The planned guidance to support social landlords to use the provisions of Section 18 of the bill will include details of the steps landlords should take to help support victims who are, for example, left with rent arrears as a result of their partner's actions, or who are unable to meet the rent because of the economic abuse by the perpetrator. The Scottish Government also intends to amend the pre-action requirements set out in the Housing Act 2001 to require social landlords to recognise the effect and impact that financial coercion can have on rent arrears and ensure domestic abuse is fully considered before any court action for rent arrears can be raised. Amendment 49 would mean that landlords would not have the option of raising eviction proceedings against the tenant in any circumstances for a period of 6 months following court action to transfer a tenancy and end a perpetrator's interest in the tenancy. Landlords need to have the ability to raise eviction proceedings at any time, for example, to deal with serious cases of criminal activity or indeed antisocial behaviour, which is having an impact on surrounding neighbours. They also need to have legal remedies for dealing with significant rent arrears, where a tenant has not taken up offers of support and is refusing to engage with the landlord. To allow this amendment to proceed would impact upon the landlord's right to access these remedies and could adversely impact on the safety of other tenants. Amendment 50 would create a new tenancy from the date the order is made. If the perpetrator's interest in a joint tenancy was ended by court order, the remaining joint tenant would continue as a sole tenant under the existing tenancy agreement. As such, there is no new tenancy agreement to enter into, and entering into a new tenancy agreement would not be required. In cases where a sole tenant perpetrator is evicted, the landlord would enter into a new tenancy agreement with the victim. Sole tenant is part of that process. I hope that these observations are sufficient to give Rhoda Grant some assurances and reassurances about what happens following the operation of the provision in the bill, persuade her that the amendment is not necessary or appropriate. Amendment 51 proposes that an order recovering possession where the perpetrator is a sole tenant must specify that the landlord offers the victim a tenancy agreement in respect of the house to which the eviction action relates. As currently drafted, there is no specific legal requirement for a landlord to offer the tenancy to the victim where the existing tenancy is a sole tenancy, although the ground of recovery does require the landlord to intend to do so. Creating a legal requirement for the landlord to offer a tenancy to the victim would provide further certainty for victims and strengthen their protection in these cases. However, at this point, while I support the principle of the amendment, there are some technical issues with it which need to be worked through. So on the basis of an agreement in principle, I'd be asking Rhoda Grant not to move Amendment 51, and I'll work with her between Stage 2 and Stage 3 to develop a suitable amendment that delivers the policy intent she requires. I thank Rhoda Grant for lodging these amendments, but would ask her not to press them. In the event that she chooses to press them, I would invite members to reject Amendment 49 and 50, and I will commit to working with Rhoda Grant ahead of Stage 3 to bring forward a suitable amendment in relation to the issues raised by Amendment 51, but in the meantime, if it is pressed, would ask members to reject that too.
Thank you very much, Cabinet Secretary. Could I invite Rhoda Grant to wind up and to press or withdraw Amendment 49?
And thank you, Convener, and I welcome the Cabinet Secretary to work with him on Amendment 59 to see if we can put further protection in place. Convener, I think I will also reflect on what he said on 49 and 50 and not press them at this stage, but reserve my right to bring them back or versions of them back at Stage 3.
Thank you. So Rhoda Grant wishes to withdraw Amendment 49. Are members content that Amendment 49 be withdrawn? Members are content. I call Amendment 50 in the name of Rhoda Grant, already debated with Amendment 49. Rhoda Grant to move or not move?
Not move.
Let's not move. Thank you. I call Amendment 51 in the name of Rhoda Grant, already debated with Amendment 49. Rhoda Grant to move or not move? Sorry, Rhoda Grant to move or not move?
Sorry, not moved.
Not moved. Thank you. So that's not moved. Thank you. And we move to the next group, in which I call Amendment 52 in the name of Rhoda Grant, in a group on its own. Rhoda Grant to speak. Sorry, Rhoda Grant to move and to speak to Amendment 52.
I move Amendment 52. The amendment seeks to remove the time limit put on the length of time a victim has lived at an address before they can have a right to the protection of their home. 6 months appears to me to be an arbitrary figure. If someone is being abused in what is their normal and sole residence, then they should not face the loss of their home because a protection order is put in place. The very aim of this bill is to protect people from homelessness, and therefore I believe that Amendment 52 gives them that level of protection.
Thank you, Rhoda. No member is indicating that they wish to speak in a debate on this group, so can I invite the Cabinet Secretary to respond?
Thank you, Convener. The policy objective of the social housing transfer of tenancy is to support and enable victims to remain in the family home and prevent the injustice of victims and their families having to leave their homes, belongings, their community to seek safety, with the perpetrator still remaining absolutely undisturbed in their family home. This amendment would, as Rhoda Grant has highlighted, remove the current requirement for the parties to have lived together for a cumulative period of at least 6 months in the last 12 months prior to eviction action being taken. I suppose by eliminating this threshold, their concern would be that action could be taken to evict the tenant where the two parties had lived together for any period of time within the 12 months prior to the action being initiated. For example, where a victim had only been living in the tenancy for a week, a few days, maybe even just overnight. In such cases, the tenancy is clearly not the victim's family home. We consider it appropriate for there to be a minimum time period for the two parties to have lived together. Our approach in relation to having a minimum 6-month cumulative time threshold recognises that abusive relationships can be volatile, can be unsettled, where victims can flee and return on many occasions before making the final decision to end the relationship permanently. A consequence of this amendment could be court action being taken to end the tenancy and evict a tenant when the tenancy in question is clearly not the victim's family home, and we would have concerns about the proportionality of the provisions being available to be used in such circumstances. I hope for these reasons I would urge Rhoda Grant to withdraw Amendment 52, but if they are pressed, I would ask the committee to reject Amendment 52.
Thank you, Cabinet Secretary. Could I invite Rhoda Grant to wind up and to press or withdraw, please? Rhoda.
I'm disappointed by what the Cabinet Secretary said. I think it's very clear that if somebody has to live in their home for 6 months to get protection, then we are failing to protect quite a large number of people. Domestic abuse may not become apparent in years to come. It may become very apparent. They cohabiting for something like 3 months, you begin to realise domestic abuse is an issue. And if we are only protecting people who have lived together for over 6 months, I believe the bill is not doing the right thing, and therefore I wish to press Amendment 52.
Thank you. So the question is that Amendment 52 be agreed to. Are we all agreed? We're not agreed. There will be a division. So can I invite all members in favour of Amendment 52 to type Y into the chat box now, please? Thank you. Could I invite all members opposed to Amendment 52 to type N into the chat box now, please? And could I invite any member abstaining on Amendment 52 to type A into the chat box now, please? I haven't got a result yet from the clerks. I'm just waiting for one to come. Thank you. The result on Amendment 52 is that there was 1 vote in favour and there were 8 votes against. There were no abstentions. Those voting in favour were Rhoda Grant, and those voting against were all other members of the committee. The amendment is not agreed. The question is that Section 18 be agreed to. Are we all agreed? We are agreed. Then we move to the next group, which is the last group to be debated today, which concerns Scottish secure tenancies in cases involving abuse abusive behaviour. And I call Amendment 53 in the name of Rhoda Grant in a group of its own. Rhoda Grant to move and to speak to Amendment 53.
Move Amendment 53. It's important that the victim has the right to stay in their own home if that's what they wish, but it's also important that they have the right to move, whether that's due to emotional, safety or economic concerns. This amendment aims to make a separate provision in relation to victims who do not want to stay in their existing home. That aims to ensure that they are rehoused without having to be made homeless. This obligation should fall on all registered social landlords, housing associations and council tenancies. The aims of this bill is to keep victims in their own homes. However, in certain situations, it is unsafe for them to do so. So, only if requested by the victim, provision should be made to rehouse them into suitable accommodation.
Thank you, Rhoda. No other members indicating that they wish to speak in a debate on this group, so can I invite the Cabinet Secretary to respond, please?
Convener, and I note again from the briefing that you've been given by Scottish Women's Aid that they do not support Amendment 53, and again I'll articulate much the same reasons as they do in the briefing. The primary purpose of Section 18 of the bill, as we know, is to enable social landlords to transfer a tenancy to a victim of domestic abuse and support and enable them to live in the family home. This amendment broadens Section 18 into the bill into really somewhat new territory and replace a legal obligation on a social landlord to rehouse a victim in a different tenancy on their request, where they do not wish the landlord to pursue a transfer of tenancy for the family home on their behalf. There are already existing legal safeguards in place to support rehousing of domestic abuse victims, with social landlords having to give reasonable preference to certain categories of applicants in allocating tenancies, including those who are homeless or threatened with homelessness. Social landlords will routinely work with the victim and other support agencies in determining what is the best housing option to provide safety and stability in the long term. This will include whether the family home or moving to a new tenancy elsewhere is the best option. Where a move to a different tenancy is considered the best option, sometimes that means being housed by a different social landlord to ensure victims are not housed in the vicinity of the perpetrator for their safety and security. I think putting a legal requirement on a social landlord to provide a different tenancy could be challenging for landlords, particularly for smaller community-based housing associations, where the availability and location of their housing could potentially put victims in further danger if they're required to offer them a different tenancy within their own housing stock. For this reason, I would ask Rhoda Grant to withdraw her amendment, and if it's pressed, I would ask committee to reject Amendment 53.
Thank you, Cabinet Secretary. Can I invite Rhoda Grant to wind up and to press or withdraw Amendment 53, please?
I'm disappointed with the Cabinet Secretary's response. The aim of this amendment is that victims of domestic abuse wish to move out of homelessness legislation. The Cabinet Secretary again stressed that there is homelessness legislation that covers people who are both homeless and people threatened with homelessness, but this could end up that a victim of domestic abuse is in temporary homeless accommodation with their family rather than being rehoused into suitable accommodation. I will not press this amendment at the moment, but I reserve my position to bring back a similar amendment at stage 3 that offers the protection to victims of domestic abuse that they do not end up in temporary homelessness accommodation.
Okay, thank you. So Rhoda Grant would like to withdraw Amendment 53. Are members content that Amendment 53 be withdrawn? Members are content. The question is that sections 19 to 21 be agreed to. Are we all agreed? We are agreed. The question is that the long title be agreed to. Are we all agreed? We are agreed, and that ends stage 2 consideration of the bill. The bill will now be reprinted as amended at stage 2 and will be published tomorrow morning. The Parliament has not yet determined when stage 3 will be held. Members will be informed of that in due course, along with the deadline for lodging stage 3 amendments. In the meantime, stage 3 amendments can now be lodged with the clerks in the legislation 2014. We have two more public pieces of business to transact this morning, and then we will move to private to consider our last remaining item. And the two remaining pieces of public business are to consider two affirmative instruments. The first of which is the Criminal Justice Scotland Act 2003 Supplementary Provisions Order 2021. And I refer members to the relevant paper in the pack, which is a note by the clerk. We have the Cabinet Secretary with us still and his officials, and I invite him to make a brief opening statement on this instrument, please, if you would, Cabinet Secretary.
Forgive me, Convener, I lost you at what was probably the important point. Did you want me to speak to the Criminal Justice Scotland Act 2003 provisions first?
Yes, please. Yes, thank you.
Yeah, happy to do so. Thanks, Convener. Thanks for inviting me to speak in support of the affirmative instrument. Currently, victims of certain crimes are eligible to make a victim statement. This is a written statement that tells the court how a crime has affected the victim physically, emotionally and financially. The judge or sheriff takes a statement into account when it comes to sentencing. The list of offences for which a statement can be made was prescribed in 2009. Since then, a number of new offences, such as stalking, for example, have been introduced for which a statement cannot be made. Statements are also limited to solemn proceedings currently. We consulted in 2019 on widening the scope of the current scheme to give more victims the opportunity to have their voices heard. The findings of the consultation make it clear there is an appetite for change, such as widening the lists of eligible offences and piloting new ways for victim statements to be made. Section 14 of the Criminal Justice Scotland Act 2003 provides ministers with the power to prescribe the court and offences where victim statements can be made, and indeed their form and their manner. It does not provide that different provisions can be made under these powers for different purposes. This means that some of the options favoured in the consultation cannot be implemented. For example, statements could not apply to a combination of all solemn offences and a subset of summary cases. We also cannot develop pilots to explore issues like what the take-up is by victims and the resource implications for the criminal justice system and indeed third sector organisations. So this order will address this by allowing the powers related to victim statements contained in the 2003 Act to be used in a flexible manner in terms of which courts and for which offences they will apply to. If this is approved, and once this SSI comes into force, this will allow for further engagement with key partners in the detail of proposed changes to the scheme. The consultation demonstrates that there is an interest in enabling all victims to make a statement. That would represent a significant change to this. In their consultation response, Victim Support Scotland highlighted they would have to consider whether additional resources would be required to address an increase in demand for victims seeking help in terms of completing their statement. It is therefore sensible to take a phased approach to widening the scope of the scheme and investigate issues such as the resource implications for victim organisations and, most importantly, the impact on victims themselves. This order will allow us to have that flexibility. In supporting this order, the committee will ensure that powers relating to victim statements can be used in that flexible manner and ultimately provide more victims with the opportunity to have their say.
Thank you very much. Could I just ask the Cabinet Secretary to explain why the Scottish Government is using the process that it appears to be using? And I'm not sure that I fully understand the technical implications of this, but it has been drawn to the committee's attention by the DPLR. And what appears to be happening here, as I've misunderstood it, is that the Scottish ministers are proposing to engage in what the DPLR committee has described as an unusual or unexpected use of delegated powers conferred on ministers by using a power in section 84 of the 2003 Act to substitute provisions in section 14 of the same Act as amended by the 2014 Act, namely the Victims and Witnesses Scotland Act 2014, which is not clear, but I hope accurate. And in other words, delegated powers appear to be being used to expand the scope of ministers' delegated powers. The DPLR committee has concluded that whilst that is within vires and is therefore, in its view, lawful, it is nonetheless as I just said, an unusual or unexpected use of delegated powers. And the DPLR committee has said that that is something that the lead committee, namely the Justice Committee, might wish to raise with the relevant minister when taking evidence on the instrument. That's why I do raise it now, just to get on the record the Scottish Government's explanation as to why it's using that rather convoluted procedure, if I have understood it and summarised it correctly.
Convener, I don't disagree with the DPLR's description that it is an unusual process take or an unexpected use of the power in Section 84(1) of the 2003 Act. We are, to answer your question, using this process because it is probably the most expedient way of doing it. We do not think to introduce primary legislation would be the most effective way to do this, and frankly speaking, we are not sure that we could achieve the outcome we wish to achieve in the manner and with hopefully the pace we wish to achieve without taking the action that we take. You're absolutely right to reference the fact that the DPLRC did say, of course, that there's no suggestion that the instrument is out with virus. I think that's important to put on the record. But this is, as I say, the only way we feel we can achieve the outcome we wish to achieve without there having to be primary legislation.
Okay, thank you, Cabinet Secretary. No other member of the committee has indicated that they wish to ask any questions or make any comments in relation to this FSI, so we can move, I think, straight to the formal business in relation to it. The motion is motion 23986, that the Justice Committee recommends that the Criminal Justice Scotland Act 2003 Supplementary Provisions Order 2021 be approved. Cabinet Secretary to move. That's moved. So the question is that motion 23986 in the name of Hamza Yusuf be approved. Are we all agreed? We are agreed. Thank you. The next affirmative instrument that we need to consider is the Community Orders Coronavirus Scotland Regulations 2021. Again, I refer members to the relevant paper in the pack, and also to a letter from the Howard League Scotland and from Dr. Hannah Graham in relation to this order. And I invite the Cabinet Secretary to make a brief opening statement on the instrument, and I'll then take questions from members. Cabinet Secretary.
Thank you for inviting me this morning to give evidence on the proposed Community Orders Regulations. It might be helpful to the committee if I briefly set out the Scottish Government's position. We're seeking parliamentary approval to reduce the unpaid work or other activity requirements of some existing community payback orders. This is to help us to ease pressure on local authorities as the pandemic continues and to ensure that the community justice system can continue to operate effectively. Committee members will be well aware of the enormous impact the COVID-19 pandemic has had on the justice system. I've been impressed with the continued adaptability, the resilience, the hard work demonstrated by those across the system. In particular, I'm extremely grateful to the justice social work, unpaid work teams, third sector partners and others who've all continued to deliver community justice services and related support in the context of necessary public health restrictions. Throughout the pandemic, justice social work have continued to deliver many of the requirements of CPOs and to prioritise high-risk cases. However, one area that has proved particularly challenging, I hope for understandable reasons, has been the delivery of unpaid work hours. Due to capacity constraints as a result of adhering to local and national restrictions, it has not been possible to deliver unpaid work hours at the pace which is usually expected. Latest data suggests that there is likely to be more than 800,000 hours now outstanding across Scotland, and the significant reduction in justice social work capacity means there's a high risk that these will not be deliverable within timescales expected by the courts. This could lead to the system not only being completely overwhelmed, but sheriffs and the public losing confidence that CPOs can deliver justice at all. Significant barriers will remain to areas operating at full capacity once the latest restrictions are eased, as inevitably some of these will remain in place until the vaccine rollout is complete. At the same time, we expect the volume of unpaid work hours to rise significantly as court business resumes. As has been highlighted to the committee in previous correspondence, Social Work Scotland have indicated that if no action is taken, this could lead to the system becoming overwhelmed. Similar concerns have also been raised by Community Justice Scotland and the Scottish Association of Social Work. Additionally, Scottish Government analysis suggests that if court business returns to pre-COVID levels, while at the same time the capacity to deliver unpaid work remains constrained, there could be in excess of 1 million hours outstanding by July if no other action is taken. This means there is clear potential for what is already a very challenging situation to become significantly worse. I take these concerns seriously, which is why I consider that action is now necessary to ensure existing orders can be delivered safely within a reasonable timescale, and new orders can be started promptly once restrictions ease. The regulations propose to vary all unpaid work hours or other activity requirements in CPOs, reducing the number of hours imposed in each order by 35%. This reduction would apply to all CPOs imposed prior to the regulations coming into force, with an unpaid work or other activity requirement where hours are outstanding. The only exception to those are CPOs imposed either entirely or partially for domestic abuse, sexual offences or stalking. The exclusion of domestic abuse, sexual offences and stalking is intended to mitigate risks arising from the very particular barriers that exist in relation to the reporting of those offences, some of which we've discussed during our Stage 2 proceedings, and they are not found to the same extent with other offences. The Scottish Government and other justice organisations have taken steps to reduce these barriers in recent years. I acknowledge these are extraordinary powers intended to be used only if absolutely necessary. Under ordinary circumstances, we would never propose or even consider proposing altering sentences imposed by the court. It's a sign of just how much of an impact the pandemic has had that we're here today doing just that. I can also assure victims of crime and others that the justice system continues to hold those who commit offences to account and to keep our communities safe. The proposed regulations focus specifically on unpaid work or other activity requirements only, with all other requirements remaining in place. This means individuals who require supervision or specific interventions to address their offending, that continues to happen. The proposed regulations strike, I would suggest, an appropriate balance between removing enough hours to assist justice social work services and ensuring that individuals complete the majority of their unpaid work requirement as imposed by the courts. Convener, this is a proportionate and necessary response to a global pandemic which helps ensure Scotland's justice system can function effectively in extraordinary circumstances. I hope this is helpful, and of course I'm happy to take any questions.
Thank you very much, Cabinet Secretary. 4 members have indicated that they have questions, so I'll take them in order: Liam Kerr, Rhoda Grant, John Finney and Fulton McGregor, and I'll take all of those interventions and questions and then come back to the Cabinet Secretary to respond to them all together, if I may. So Liam Kerr first, please.
Thank you, Convener. So, Cabinet Secretary, 2 parts to what I'm going to ask here. So just to be clear, in practical terms, so that viewers can understand exactly what's happening, this means a criminal, part of whose punishment a court felt should be in the form of unpaid work, will have that punishment written off and nothing will be put in its place as punishment for the crime. And if I'm right on that, you see, I'm not sure that victims will see that as, I think the Cabinet Secretary's quote was, holding criminals to account. Can the Cabinet Secretary also, having confirmed that that is the case, confirm what precisely has the Scottish Government been doing during this period to address these issues, to anticipate these issues, and ensure we didn't find ourselves in the position that we appear to today?
Okay, thank you. I'll invite the Cabinet Secretary to respond to that after we've heard from Rhoda, John and Fulton. And Rhoda Grant next, please.
Okay, thank you, Convener. This is, I think we all understand we are in a pandemic. Regard to people's safety, I think we take that as read. But I do have some concerns about this because those were punishments as well as actions to divert people from offending behaviour that were handed down by the courts. So I wonder what discussions the Cabinet Secretary has had with sheriffs to ensure that they remain confident in community disposals. Because the last thing we want to see is this action meaning an increase of people in prison, which under a pandemic has its own risks. So we need to be very, very careful I also would like to ask what consideration has he given to putting alternatives in place, things like online education that would take the same time commitment as unpaid work, but would actually leave people with possibly a qualification or something they could build in future that would use the time that they were to set aside as reparation as well. And how is he going to ensure that action as part of the sentence that was taken to divert people from offending behaviour, that still takes place? Because otherwise we put people on a merry-go-round where they are in and out of court. We need to address the offending behaviour and make sure it's not repeated. So what steps has he taken to ensure that this action doesn't in any way detrimentally affect that?
Thank you, Rhoda. Again, I'll invite the Cabinet Secretary to respond to that in due course, but first I want to hear from John Finney, and after John Finney, it'll be Fulton McGregor, please. John.
Thank you, Convener. A few comments and then maybe a couple of queries to the Cabinet Secretary, if I may, please. Fully endorse this position. This is pragmatism. Indeed, it would be blissfully naive to assume that unpaid work hours wouldn't be in any way impacted by a global pandemic, just like everything else has been. I wonder, Cabinet Secretary, with regard to the exclusions, and we have representations from the Howard League, excuse me, surely it's the case, and you know that I'm a very strong supporter of strong measures to be taken against perpetrators of domestic violence, but surely if a decision has been taken to have a disposal that involved unpaid work, that was informed by a risk assessment. Now, I would like to think that risk assessment is an ongoing process, so is it populist to exclude some of these categories? Of course, I understand the pernicious nature of domestic violence, of stalking, and crimes where there's almost a psychological aspect, but that is something that's been taken account of when presumably the sentencing sheriff has reached their disposal. So I wonder if you could comment on that, please. And with regard to a letter we've received from Dr. Hannah Graham regarding ECHR compliance, are you content that there's a robust legal basis for this? I know you don't, by convention, share your advice with us, but could you comment on that as well, please? But as a general principle, and of course I would agree with my colleague Rhoda Grant about the activity being meaningful, and if there are alternatives, the extent to which they can be explored. But I think we have to be realistic. We're aware of the challenges that exist throughout our criminal justice system. They're no different from challenges in every walk of life. So absolutely support the pragmatism here, but if you could address these two issues, please. Thank you.
Thank you very much, Mr. Finney. Fulton McGregor will be next, and then after Fulton McGregor will be Liam MacArthur, and then at that point, I think I'll turn to the Cabinet Secretary. Fulton, please.
Thanks, Convener. A bit like John Finney, I just want to say that I completely agree with what's been put forward by the Cabinet Secretary. I think we need to be pragmatic here. I would disagree with Liam Kerr, who opened up the discussion on it when he was talking about that justice could be brought in and distributed. Well, I think if we don't do anything, the Cabinet Secretary is right that's exactly the effect that we could have come July or August or whenever that may be, when there are millions of hours of unpaid work not being done, and that is more likely that sheriffs would lose faith in the CPOs. But also, I think that it's important to say that the Cabinet Secretary did say that it's where unpaid work is the only thing that this deduction would not be brought into place. I think that that's important as well. I suppose my concern is actually on the other side of what Liam Kerr and Rhoda Grant had said is, and I'd actually question whether the Cabinet Secretary thinks that 35% reduction is going to be enough. And I say that because we don't know how long restrictions are going to continue to last for. We don't know if new restrictions will be needed. We all hope that they won't be. But is there a review built in? Apologies if I missed this. To consider whether actually further reduction might be needed at some point, or, as Rhoda Grant and John Finney both said, whether that could be replaced with something else, that might work as well. So I think that that's probably all I wanted to say on it, and just that one question for the Cabinet Secretary in summing up. And convener, I probably should register my interest at this point as well, as a registered social worker with the SSC. Thanks.
Thank you very much, Fulton. Liam MacArthur, please.
Very much indeed, convener. I think, as other colleagues have suggested, from my perspective, this appears to be a pragmatic response to a challenge, one of the very many challenges that have been thrown up by the pandemic. And I think, as Fulton McGregor said, the option of doing nothing, sticking our fingers in the ears and just wishing it away, is not a response for which the public would be terribly grateful either. I think when we see reports over the course of the last week of significant COVID outbreaks within our prison estate, which already is bursting at the seams, I think a pragmatic approach along the lines suggested by the Cabinet Secretary in relation to these orders is a reasonable approach to take. I think the point made by John Finney in terms of the exclusions is one that I would hope the Cabinet Secretary will address, because, as John Finney rightly said, all of this has to be done on a basis of risk. If that risk has been assessed, as orders were deemed to be appropriate, then it's difficult to see how an intervention excluding some offences and not others can be justified in terms of the approach now being taken in terms of discounting. So I'm sure the Cabinet Secretary will address that, but I just wanted to back up what John Finney was saying in that regard. Thanks.
Thank you very much, Liam. I mean, the issue that has been puzzling me, Cabinet Secretary, as I've listened to this debate, and it's not often we have such a lengthy debate on an affirmative SSI as this, but the issue that's been puzzling me as I've been listening to the debate is that given this was wholly predictable, why has the budget for criminal justice social work been frozen? So perhaps you could respond to that question, as well as the others which have been put to you by members of the committee in relation to this SSI, Cabinet Secretary.
To address that point, as well as all the other points as well. Can I I'll try to go through all the questions in the order that were given to me, but if I miss anybody out, please, I'm happy to. So Liam Kerr's point, I do not agree with his premise that we have written off community orders. We very clearly have not written off. We have reduced the unpaid work element by 35%. So that means that the majority, 65% of the hours imposed, are still having to be completed by the individual. So it's not a case of it being written off. And in terms of his question about why that could not have been anticipated, I'm not sure what exactly he means by that. I think all of us all of us realise the effect of the global pandemic, the challenges that has brought upon us. I don't think anybody could have anticipated the length of time we've had to live under, the restrictions we've had to live under, nor indeed the full impact and effect on organisations. So this isn't just a case of being able to get people back into groups of 5, 6, 7, 8 and getting into a minibus and going off to go paint the local community centre. It's about the fact that resources at a local authority level had to be diverted away from criminal justice social work and put into other departments to respond to the COVID-19 pandemic. So because of all these reasons, that is why we're in the situation we're in. Rhoda Grant makes, I think, some excellent points. I have had discussion, as have my officials, with sheriffs, and what I would say to Rhoda Grant is that we're obviously talking to them, as Community Justice Scotland are, about the plans that we have, and clearly our concern would be that if the system is overwhelmed, then sheriffs would have no alternative but to give people a custodial sentence. And as Liam MacArthur suggests, doing that at a time when our prisons are already, or some of our prisons are already full, would not be a wise move. Rhoda Grant makes some other helpful remarks. Yes, just to give her some absolute assurance, the interventions that are in place in a community order when it comes to addressing somebody's offending behaviour, they're not affected by the reduction in unpaid work hours. So if those interventions are still necessary to address their substance abuse issues, for example, then those interventions will continue, or at the very least, they are not affected by the 35% reduction. Alternatives by some local authorities have been pursued where that's possible, and again, that has been done at a local authority level. John Finney's questions. Yeah, I could probably be accused of a lot of things, but being accused of being populist on this is probably not one of them. This is probably not a particularly popular policy, generally speaking, but it is a necessary policy for us to take forward. It is not just pragmatic, sensible governance, and I think that is really important for us to address head on. In terms of the question that he asks, and Liam MacArthur asks, and I think by the Howard League and Dr. Hannah Graham, both organisations that I listen to, organisation in terms of Howard League and an individual like Hannah Graham that I listen to quite carefully, I can give an absolute assurance for us that we do have a legal basis for what we're doing. ECHR, under ECHR Article 14, you can have objective justification for treating various people and categories differently. For us, the offences that we have excluded in this case, we have done so because of the unique dynamic involved, i.e. what tends to be the case in the majority of these cases, the dynamic of men's power over women, and the barriers that exist when it comes to domestic abuse, sexual offences and stalking. Those barriers are different when it comes to different other offences. That's not to say there aren't barriers to reporting. For example, for hate crime, there are, I know that, but they're a very unique dynamic when it comes to those offences, and we believe we are legally justified in the exclusions that we have. Fulton McGregor's point is a fine point as well. He'll note probably that Social Work Scotland asked us to go further than we actually did. So there's not a review mechanism built in per se, but it is an issue that we keep under review, if that is helpful. On the budget question, all I would say to the convener is that we have allocated £50 million in terms of our recovery, renewal, transform project. A lot of focus on that 50 million, understandably so, goes onto the backlog of court cases, but I can confirm that 50 million will also be used to bolster the community justice arm of the justice system as well.
Okay, thank you. I think we should move to the formal consideration of the motion in relation to this instrument. So the motion is motion 24033, that the Justice Committee recommends that the Community Orders Coronavirus Scotland Regulations 2021 be approved. I invite the Cabinet Secretary formally to move. That's moved. So the question is that motion 24033 in the name of Hamza Youssef be approved. Are we all agreed? We're not agreed, and there will be a division. So can I invite members of the committee in favour of motion 24033 to type Y into the chat box now, please? And can I invite members of the committee opposed to motion 24033 to type N into the chat box now, please? Thank you. And any member abstaining on the motion type A into the chat box now, please. Thank you. The result on the motion 24033 is that there were 7 votes in favour and there were 2 votes against. Those voting in favour were, I've lost my list of members of the committee, so excuse me. Those voting in favour were Rona Mackay, Annabel Ewing, John Finney, Rhoda Grant, Fulton McGregor, Liam MacArthur and Shona Robertson, and those voting against were Adam Tompkins and Liam Kerr. I hope I got that right. Thank you. I invite the committee to agree to delegate to me the publication of a short factual report on our deliberations on both the affirmative SSIs today. And that concludes the public part of our meeting today. Our next meeting, I think, is scheduled to take place a week today, but that will be confirmed in due course. And I now close the public part of this meeting, and we will move into private on MS Teams. Thank you.